transcripts of the entire proceedings to date. Can you hear me, Honourable Chair?
Yes, I hear you.
Oh, sorry, I just see something on this screen there which says dismiss, rejoin. Yeah, it's almost time to conclude this process, and we need the transcripts of the witness evidence to get to us as soon as possible. So if you could assist to speed that up from your side.
Yeah, because they should help you in the compilation of the report.
Yes, that we have discussed with the parliamentary team, and we've actually met and decided on a modus operandi on how to go about doing that. That's fine. But the transcripts itself from witnesses' evidence, if we want to hand to the Honourable Committee an accurate summation of the evidence, then the transcript is important.
Okay, that point is taken. Can we move to the second item?
Honorable Chair, I see there is a hand from Honorable Kolapanat.
Yes, Chair, if I may.
You are welcome, Honorable Barnett.
Thank you. I've managed to fix my microphone issues. I just wondered, we had proposed, or it had been proposed once or twice, that the Inspector General of Intelligence should be called before the Ad Hoc Committee, given the issues surrounding his report and his claims against the top 3 members we've been interviewing. So I would have thought he would be on that list. Is there some reason he is not?
Okay, Senior Counsel.
Chair, I'm just trying to... Is my microphone still on?
Yeah.
Okay, thank you. Honourable Chair, Honourable Kolapanat, you may recall that we had actually been required to fit him in as a witness last year already. And several attempts were made with the assistance of the Chair, Honourable Chair of this committee, Chair of Chairs, to arrange meetings for us with the Chair of the Joint Intelligence Committee. That didn't happen last year. And I think the Honourable Chair did, Chair, you must correct me if I'm wrong, you did explain to the honourable members, I think it was the week before last or last week, that you and I and my colleagues, we did have a meeting with the joint, with the Chair of the Joint Intelligence Committee. And their view was that whatever happens should take place before that committee, and essentially, which puts the suspended IGI off limits to this committee. I have, though, in recent weeks, had several requests from the suspended IGI's council, from third parties, for him to appear. We looked at the legislation and what was required for him to appear, and subject to the suspended IGI consulting with the President and the Minister, Honourable Minister of Intelligence, there doesn't appear to be such impediment to him appearing. I don't know how long that process would take or would have taken. I also had a confidential online or telephonic discussion with the Minister, the Honourable Acting Minister of Police, because the suspended IGI, in fact, before his suspension, had handed over his report to the acting minister, who had indicated to him that he would prefer not to act or take any action because of the two ongoing inquiries, and would prefer to await the outcome. I'm not disclosing the contents, so I don't think I'm in breach. He did mention to me, though, that the suspended IGI had a meeting with him. The General Masemola, General Mkhwanazi, Lieutenant General Khumalo had also attended a meeting with him to discuss the report. And I think it was last week, they had also appeared before the Intelligence Committee and had explained their point of view. And that's where the matter is left, Honourable Chair. So we have not scheduled him, not for that reason, but also for the reason that, if my memory serves, I didn't get the impression that the honourable members of this committee were almost insisting that he should appear.
Okay, that was a question for clarity. We are still going to rotate the schedule for discussions, and we will hear what the members say, unless if there is still a further clarity seeking questions. Okay, can we present the next item?
Chairperson. Afternoon, Chairperson. It's Talana.
Talana, good afternoon. How are you?
I'm fine, Chairperson.
Yeah.
Yes. So, for those who don't know me, my name is Talana Halley, and I've been assisting Andile throughout the duration of the matter. I was tasked with supporting the committee in coordinating the President's questions arising from the Ad Hoc Committee process. As members are aware, the deadline for submissions of the questions for the President closed on the 12th of February. By that deadline, we received 4 questions from Council, 102 questions from the EFF, 9 from the MK Party, 14 from the ANC, and 7 from the DA. Legal Service considered all submissions and consolidated the questions, and where duplications arose, these were combined, resulting in a final consolidated list of approximately 122 questions. This list was then forwarded to the committee secretariat for the onward transmission to the chairperson, and that was done on the 16th of February 2026. We now seek confirmation from this committee that the consolidated questions may be transmitted to the President by close of business today. Thank you, Honourable Chairperson.
Thank you so much. I think what we should do, Talana,
Yes, Chair.
is to formally, because now the consolidation of the questions have been made, you just formally release that consolidation if it has not been released. I
Yes.
have that, yeah, and then because this week, we will be meeting the whole week. Members can, or the respective parties can just okay the questions if they are satisfied that all the questions that they forwarded to you are captured in your consolidation.
100%, Chairperson.
Yeah. I think that will be the best approach, the proposal to make before the meeting, to say, we are presenting the consolidation before you. We want you to take this consolidation and satisfy yourselves that all your questions have been captured. There would have been questions coming from the EFF or the ANC or the MKP, which were replicating. and that will become one question in the consolidation process. But the substance of the question has not been changed either way. But be that as it may, we want all of you to see this consolidation and compare against the questions that you have sent and satisfy yourselves that your questions can now go to the destination which is intended. So
Yes.
I'm going to now start. Thank you so much for the presentation. I'm going to start rotation on the members. When they speak, they will speak on the schedule as presented and the proposal on the question to the president as tabled here. Are we ready? Can we start African National Congress?
Thank you very much, Chairperson. We have noted the schedule of the hearings proposed. We did have a question on whether one day was enough for Mr. Brown Mkhwanazi, but we will be guided by the chair, and I suppose the meeting on that. I'm not sure, given that other witnesses who to be as involved as Mr. Mkhwanazi, we're sometimes given more than a day, but it's not a fundamental issue for us, Chair. And then the second issue on the Inspector General of Intelligence, the African National Congress, and I suppose like many of the other parties, was very clear that we would like the Inspector General to be invited to appear before the committee. We were, however, under the impression that following your engagements with the JSCI, that was not possible. So I'm not sure if the input coming from the evidence leader advocate Arends is that if we are to push strong enough, the IGI would make himself available, especially given, if I understood correctly, that the IGI seems to want to appear before the committee himself. So we would definitely support a push to ensure that the IGI attends. On the questions to the President, Chairperson, we support the approach that you are proposing, that those questions are circulated and that political parties just double check to ensure that the essence of their questions has been captured. Thank you very much, Chair. I'm not sure if there's any other additions from the African National Congress. Thank you, Chair. Chairperson, I'm done.
Have we lost the chair?
I'm saying that I don't see any indications for additions in the African National Congress. I'm going to move to the MKP for Honorable Skhosana.
Thank you, Chair. I'm not sure as well whether the issue of Brown Mkhwanazi, if one has to take the last appearance in the other committee, maybe, I've got a benefit of a doubt whether we need 2 days for Mkhwanazi, but maybe if we have an extra day, where perhaps if we won't be able to finish in 1 day, but I guess in my view that we will definitely finish in 1 day. But I don't have a problem with the suggestion that in case we don't finish in 1 day, we'll take him for another half day like we did with other witnesses. And coming into the issue as well, Chair, that the one way is to welcome, the extension which was granted to us as well. And perhaps these other witnesses, like the one, the Inspector General.
Honorable Skhosana, so that you can make a contribution to this debate. Can we check with the senior counsel, how long do they intend to present Mr. Mkhwanazi's evidence?
Okay.
Chair, Honorable Chair, can you hear me?
Yes.
Thank you. I'm just having a can't see clearly from my screen. We would intend to lead we would intend to lead Mr. Mkhwanazi until about 3 o'clock, 3:30, latest 4. What I neglected to mention was that it was indicated to us, and obviously subject to you, Honourable Chair, and the honourable members, that the next day, which is budget day, that if there is an overflow, that perhaps another 2, say maximum 3 hours could be set aside to conclude his evidence. That is what we had in mind and in discussion with Andile.
Yeah, the members that you have in this committee are leaders of political parties, and on a budget day becomes a very hectic day for them because they are doing
budget day is out.
Interviews and many things. Yeah, the log-in session. So there are many activities around the budget day which are going to keep members away. And if let's say you run until 4 tomorrow, and you need all the members of the committee to speak, it means they are going to finish somewhere around 11 o'clock tomorrow, midnight. Unless if the meeting agrees to start earlier at 10, and then you lead evidence until 14 hours. You agree that the meeting will start at 10 and evidence will be presented until 14 hours. You take a 30 minutes break and then come at 2:30. I think that can be the ideal start.
I think that will work, Honourable Chair.
Yeah?
That can definitely work.
Yeah, and if it does not work, the only time we can start taking questions must be 3 o'clock. That one cannot be negotiable. Because starting questions at 16 hours, you take 2 hours from 16 hours, 3 hours from 16 hours to 19 hours, you take a break. And then you come back from 19 hours from 20 hours to 22 hours, the second session. So we normally take 3 or 4 sessions. So can we agree that let's push and have everything, especially the presentation of evidence, concluded by 15 hours tomorrow?
Yes, Honourable Chair, although I'm speaking on behalf of my colleague, Ms. Mkhwanazi, who is going to lead his evidence.
And it's until 14:30.
I will instruct her to finish by 15.
Or 14:20, and then we break for 40 minutes. We come back at 15 hours. In that way, we can be able to take all the speakers.
Yes, Honourable Chair.
Yeah, I just wanted so that when members speak, they can also speak to that point. Honourable Skosana.
Thank you, Chair, for that clarity. You know, I'm not sure whether other members, the issue of 10, if we agree, it's fine. You know, But if we agree with 11 as usual, it's okay as well. But I wanted to, I agree on that we can finish, tomorrow. And coming to each of the Inspector General as well, I really appreciate that at last we'll have somebody from that body, and the other issue I raised at the end. Thank you, Chair. About the other issues which was contagious, the issue of the judiciary, but that will come up later in any other business. Thank you, Chair.
Okay, thank you so much, Honorable Member, the DA.
If I may, Chair, yeah, thank you. I agree with the ANC who did, in fact, ask that the Inspector General should attend before us. I think there are many matters that he could clarify that are all in the media and could explain a great deal about what is going on, none of which would break any confidence in terms of clearance. So I think it's crucial that he comes before this committee. I would ask that some space is made for him. Thank you.
Okay, Honorable Cameron.
Chair, just want to echo the words of the Honourable Kola Barnard. I think it's important that this committee can't be dictated to by any other committee or other chair regarding who we do and don't have. The Inspector General must come and appear before this committee. Thank you, Chair.
Okay. The EFF.
No, we agree, Chair, that Inspector General must come, but equally, we agree on Mkhwanazi that the sufficient time must be made available, especially for members to ask questions. So we are covered.
And then the proposal on a consolidation of questions to the President.
Yeah, there we agree.
Okay, DA, do you
because
agree?
Obviously others are repeating themselves. The questions, the others will repeat and all of that. So consolidated becomes a committee document.
Okay, let me go back to the DA and check if they agree with the consolidation process.
Yes, Chair, we agree.
Okay, Honorable Skosana, the consolidation process, do you agree?
No problem, Chair. I agree.
Okay, Honorable Sols.
Chair, on the issue of Brown Mkhwanazi, start at 10 is fine. On the issue of the consolidation of questions, we agree. And then we also agree that the IG must come. Thank you, Chair.
Honorable Vessels.
Thank you, Chairperson. I'm covered. So also agree that the IGI should appear and agree with the other proposals. Thank you, Chair.
Okay, Honorable James.
Thank you, Chair. On the Inspector General, we support that, the consolidation. We support the IG. We support starting at 10 o'clock for Mr. Mkhwanazi. We support that. And we'd also like to propose that going forward, can we not start at 10 o'clock for all witness appearances until we conclude? That would be appreciated. And then also, Chair, the scheduling and the list of the witnesses, we also support that. I think I just want to ask, what is the method that is being applied to the sequencing and in terms of when the witnesses appear? Because right now we have, I don't want to say that one witness or one person is more important than the next, but I find that we have key witnesses appearing rather late instead of sooner. Is there any method being used in terms of the weight of the allegations against, as to why that witness needs to appear so that we can have them sooner instead of later? Thank you, Chair.
Okay, can I check with the legal team if they have a response to the question that you asked?
Chair, from I don't know what the parliamentary legal team's response might be. but firstly, we are directed by the requirements of this honourable committee in terms of which witnesses appear. Then we have to consider there was a bit of a delay in terms of the extension, and then witnesses their availability have to be reassessed, reevaluated, and we have to contact them. Then there's also the issue with delays in terms of this honourable committee finalising its schedule so that Mr. Romano can send official notification to the witnesses. Some witnesses have at times indicated, yeah, I know that Mr. Romano phoned me and said you should appear on this, but I haven't received an official notice. And I've now made other arrangements. So I don't know if the answer is satisfactory, but there's been a mix of reasons why we schedule. We obviously also want to schedule those witnesses who have still to conclude, like General Pashlani, O'Sullivan. Those witnesses have to be scheduled. In view of what appears to be a unanimous view that the suspended IGI appear, we had originally scheduled him for the 10th of March, and that would be a day where we would again insert his name for the 10th of March, because that was also a date which we had discussed earlier with his council, that they would be available also on that date. We would have to shift Advocate Mashuga, who is also just going to give a limited evidence on the status of the case against Mr. O'Sullivan. That case, which has been outstanding now for a while, we don't expect that to be too long, and we can, with his leave and with his consent, fit him in elsewhere. Thank you, Honourable Chair.
Yeah, if you remember, honourable members, the committee has said that it has the prerogative to determine the list of witnesses and the sequence of appearance. What the legal team does here is to present a proposal before the committee. And if the committee agrees with the proposal, it does not become the decision of the legal team, but it becomes the decision of the committee. So what it means is that in its deliberations, the committee has that prerogative to say, witness so and so can be in this position or can come on an earlier date or on a later date. Like if you remember when we made the decision that General Mkhwanazi must be the first witness to appear before the committee, and an order of witnesses was agreed upon as to when the second will be General Masemola as the leader of the SAPS, followed by Sibiya, and so on and so forth. So when the legal team has presented a proposal before you, remember that you have the prerogative as the committee to order the appearances of witnesses. Is that adequate, Honorable James?
Thank you so much, Chair. Chair, for the sake of progress, I'm going to leave it at that. I mean, we're in the last final push right now. I think we started off well, like you said, where we are determined we're going to have General Mkhwanazi, the National Commissioner, the Minister, Sibiya, we're going to have those people at the beginning. But as things sort of continued, I found that because when they make their allegations and statements are given to us, it sort of highlights names that should appear next. And this is why I'm asking the legal team, how did they identify the appearance of witnesses in terms of the allegations made against them? Because sometimes you would have a witness appearing 2 or 3 weeks later, responding to allegations that were made maybe 3 weeks. At that point, it's quite hard to link all the statements and to keep sort of, if I can say, the top 5 people that's been implicated in all of this, at the top of our minds. So I think that is the point that I'm trying to make. I think it's clear to me that there wasn't any method really being applied in terms of we need to pursue these witnesses vigorously, because these are the ones that's been implicated, such as the likes of Mr. Brown Mkhwanazi appearing rather late at the end, such as the likes of Mr. Paul O'Sullivan. But like I'm saying, for the sake of progress, Chair, let's leave it at that, and let's continue. But everything else is supported. Thank you.
Thank you so much. Let's move to the second item. So the schedule has been accepted. The IGI will be included on the list of witnesses and allocated a date, which the committee will be given a report and will approve it. And the proposal on the consolidation has also been accepted by the meeting. Nicolette, can we take a...
Chair?
Hello, Honorable Skosana.
I'm sorry to do this, Chair. I just wanted to ask before the matter is closed. I understand that we agreed on the consideration, but there is a public participation. Maybe at a later stage, Chair, I think let me leave this. At a later stage, we have to revisit that because other witnesses still are not in this, and they've been chosen by the same legal team. So I just want to emphasize on that one. Thank you, Chair. At a later stage.
They are not chosen by the legal team. Remember, in the last meeting, we have said that a report on public participation should come to the meeting. Nicolette is going to present the report now. And
okay, thank you, Chair.
She will also clarify the names of witnesses like Chetty that you raised in the meeting. All those matters that you raised in the previous meetings have been recorded, and this presentation is meant to clarify such matters, including Gun-Free South Africa. You remember they are a civil society organization that has made a submission and could not be available on the date that was allocated to them. So as she presents, you will hear that all those matters are covered and the committee will apply itself to the report. I'm going to request that we take the public participation report and the proposal on the framework of the committee report. The proposal is presented before the meeting on how the report of the committee is going to be structured. And the decision that we are looking at from the meeting is to say, we note this framework, allow us, because a framework of the report can be something academic or near academic. Allow us as members and respective parties to go and look at this framework, the introduction, the background, the rationale, everything. And then we will come back with our inputs. I think that is the approach that we are going to request from the meeting. May we have those 2 items presented?
Thank you, Honourable Chair. Good afternoon again to the honourable members. Chair, members, I'm just going to take you quickly through the public participation report as it stands. So, as the chairperson indicated in a previous meeting on the 9th of February, the committee requested a written report regarding the basis for selection, re-evaluation, and scheduling of witnesses and interested organizations to appear before the committee. This report really responds to the request from the committee. Notably, Chair and members, this report does not address the merits of any public submissions received by the committee. The introduction is really only to set out the process that was followed by the committee and states how public participation is conducted and the importance of public participation in the work of Parliament. So, Chair, as I mentioned, the public participation process was done in accordance with the established parliamentary processes, which are designed to facilitate broad public engagement. As members know, the call for comment was advertised from 19 September with the closing date of 17 October last year. And the advertisement, I've stated here the actual wording that was used in the call for public comment. Gee, I'm not going to read through it, but it's just indicating the requirements of the committee. As members can recall, at the close of the public participation process, the committee noted that only a limited number of submissions were in the submitted format in terms of sworn statements, and mindful of the need to facilitate meaningful public participation, the committee resolved to consider all submissions falling within the scope of the inquiry, irrespective of whether they were accompanied by supporting documents or submitted under oath. On the 19th of January this year, the committee agreed that its public hearings would proceed on a non-evidentiary basis, thus focusing on lived experience, contextual input, and systemic issues relating to the inquiry. So, in terms of this approach taken by the committee, the committee's approach would not have been an opportunity for members, for the witnesses to be sworn in and to really have a very substantive engagement with the witnesses. The approach, or this approach, informed the planning and scheduling of witnesses appearing before the committee, and that's a public participation program. However, honourable members, as the public participation process progressed and evolved, the committee's approach shifted from its earlier decision to conduct hearings on a non-evidentiary basis. As I stated previously, all participants were placed under oath and subjected to extensive questioning that went beyond asking questions of clarity, which is normally the approach taken during public participation. Honourable members, as you recall, there were a number of people or individuals and civil society organizations that was identified for public of oral hearings. As I mentioned, honorable members, as the process.
Hello, Maria.
How are you? Hi.
Okay.
I saw your message. I didn't see this message from.
Sorry, honorable members. As I mentioned earlier, the adjustments to the program occurred for various reasons, including logistical constraints, the withdrawal of some witnesses and organizations from appearing at the hearings, re-evaluation of initial selection following further consideration, and procedural and or legal concerns that arose after the committee's initial identification. Honorable Chair and honorable members, I'm just going to quickly run through the submissions that have been heard by the committee during oral presentations. We had Accountability Now, the African Policing Civilian Oversight Forum, the Institute for Security Studies, and the Africa Criminal Justice Reform, the Ms. Mashale, Mr. Luwani, Captain Ramalepi, and the supporting captain and colonel that was appearing with him. We had Mr. Dodiani, Mr. Madlatu, and Advocate Maki Bula. So members, these 10 persons and civil society organizations has already appeared before the committee, and the committee has heard and interrogated their submissions. So members, I just want to clarify that Gun Free South Africa did not withdraw from the process. They were merely not available on the dates that was originally scheduled, and there was some logistical challenges, and the second date that was proposed, the organization had pre-scheduled meetings which could not be changed by them. Members, to go to paragraph 4.6, there are witnesses or individuals that was originally scheduled for oral presentation, but as I said, were subsequently re-evaluated. These include 6 individuals. Chair and members, I'm just going to go through the reasons for the re-evaluation. Dr. Gordon Rolls, he was initially scheduled, but he withdrew from the process because he cited security concerns. So members, before getting into the reasons for re-evaluation, I'm just putting here the rationale that was adopted for the original selection. There were 2 broad categories, and these are institutions and civil society inputs that provided a systemic or policy analysis. And the second category was based on submissions of first-hand experiences of the thematic approach of the committee. Members, I'm not going to read through the all of the submissions. I highlighted here the contributions from the civil society organizations, including Accountability Now, APCOF, the ISS, and the Africa Criminal Justice Reform. Originally scheduled, the individuals that would have given like first-hand or lived experience submissions were Ms. Mashale, Mr. Lawani, Captain Nama Lepi, Mr. Dogeni, and Mr. Madland. And then Advocate Makabula. Members, moving on to the rationale for re-election, members should please note that this is only procedural advice, and the re-evaluation is not based on merit. And whether individuals are heard orally or whether they only submitted written submissions, all of them really remains part of the official record of the committee, like I said, whether written or oral. Now, the re-evaluation was really based on account of emerging considerations relating to the appropriateness of oral engagement and not on the merit or substance of the submissions. The re-evaluation occurred for reasons including newly disclosed information, confidentiality obligations, ongoing and potentially reinstated legal proceedings, risk of perceived parliamentary prejudgment, and the highly individualized or dispute-specific nature of certain submissions. The first witness that was identified is Mr. Ramaphosa. He is currently on the witness schedule, and so I presume he has been contacted. He was originally selected because he advanced policy-orientated and systematic analysis. And this was based on the chain of evidence that could be used in the police and how. So he basically indicated structural challenges with the chain of evidence, and that is a key aspect of the committee's terms of reference. So, honorable members, he actually remains quite important for the inquiry. As members can remember, we had Mr. Masukua during public participation. However, during his appearance or prior to his appearance, it emerged that he was a former employee of the State Security Agency, and concerns were raised regarding whether he should actually be appearing before the committee related to possible confidentiality or confidential evidence before the committee. However, I must say that his submission relates to a complaint that he submitted to the Inspector General of Intelligence, and this was done about want to say 14 years after his employment ended with the SSA. And it is not based on classified information. It's basically a complaint that he lodged. However, having him sworn in to give testimony, he might reveal some information that has not been brought to the committee's attention. So that's really a material concern, and that he will be placing himself in a very difficult position, and that he will be in contravention of various security acts. So that is a major concern, honorable members. And again, his testimony can be taken as read. We also had quite a challenge regarding the anonymous witness that appeared before the committee. There was some confusion as to who is this anonymous person. However, members, I want to assure you that the submission that we received from the identified anonymous person, that related to a complaint of irregularity that was allegedly communicated to Lieutenant General Mkhwanazi, and the allegation is that he did not act on the information which linked to the terms of reference in that there could be some institutional leadership challenges. Then, honorable members, we had a submission from Mr. Mkhwanazi. Now, he raised significant concerns with various criminal cases that are pending before or is in currently active investigations. So that could jeopardize the investigation. However, he was originally identified because these are allegedly related to criminal cases that he opened in regards to corruption at local municipal level. It was thought good to have testimony that these issues that we are experiencing in the criminal justice system is not only located at national and provincial level, but really goes down to municipal level. However, I would really want to propose that I be enabled to send these criminal or these pending or ongoing investigations to the Office of the National Commissioner to request a report on the progress that has been made on these investigations, and that this be submitted to the committee at a later stage without providing sensitive information that could jeopardize the ongoing investigation. Members, moving on to Mr. Mpofu. This is a very individualized and case-specific submission. So the continued engagement risked creating expectations of a dedication beyond the parliamentary oversight reach. That is also regarding alleged procurement irregularities at provincial level and national. And this is really allegations, and I would not want the individual to be sworn in and to give sworn evidence that could jeopardize his case. Honorable members, moving on to Mr. Chetty. I have shared some information on the members' WhatsApp group to indicate that Mr. Chetty has criminal cases pending against him. He is currently out on bail. He subsequently indicated that he is allowed to travel. He must just inform the officer assigned to his case. However, members, he materially differs from Mr. Mkhwanazi, and although both are facing criminal charges, the charges against Mr. Mkhwanazi is immaterial. Well, it doesn't link to the scope of the inquiry. It is really charges relating to various other criminal actions. I want to say it's not related to the committee. While Mr. Chetty, while his criminal case also not related to the committee, he indicated that he experienced challenges with the freezing of his assets, but he did not indicate the scope. Well, sorry, members, just to jump back. He did experience challenges with the freezing of his assets and alleged irregular procedures by the IDAC. And that is why Mr. Chetty was originally identified for oral hearing. So he, having him sworn in to the committee and giving evidence on really unrelated aspects, it could have it could impact his ongoing trial. And honorable members, it's really just a procedural note, and it is the prerogative of members to further engage on this matter. But from a procedural viewpoint, it will be in the best interest of both the committee and Mr. Chetty to rather not appear, but that his submission will be taken as read. Honorable members, I'm just glancing over the appearance of Ms. Mkhwanazi. As members remember, she appeared before the committee as the supposed anonymous witness. However, she was not, as I indicated, the identified anonymous witness. She did not form part of the public participation process. She had a discussion outside the venue, and based on the based on these engagements, the committee exercised its prerogative to allow her to appear. As legal services will later present, we have received a correspondence in this regard, in that the person against who she made allegations have engaged with the committee and or his legal representative have engaged. So her appearance should really be seen as a very extraordinary and exceptional circumstance, and that it is, but be mindful and state clearly that she did not fall within the public participation framework. Honourable members, I just quickly have a procedural note on the previous continuation of submissions received outside the public participation period. During a meeting on 26th of January this year, Honourable Souls informed the committee of 2 public submissions that was directly forwarded to him, and that he brought it to the committee for consideration. The committee then requested that these individuals submit reasons for why they did not meet the public participation deadline. On our meeting on the 2nd of February, the reasons were presented. However, I think the detail of the reasons was not clearly articulated. Maybe so. The first submitter, he advanced medical certificates, because medical certificates, given the reasons why he could not participate and that he was also out of the country. However, members, his travel or the reason or when he was out of the country in November of 2024, which does not fall in any relevant period before the committee. Also, the 2 medical certificates provided by him, both the one predates the establishment of the Ad Hoc Committee, and the other predates the actual call for public submissions. So that is a procedural concern in that the reasons advanced by the individual really does not sustain really a good basis for approving condemnation. The second submission was basically just saying that they were unaware of the call for public submissions. However, it is very likely that other members of the public also missed the submission deadline, but lacking direct access to Member of Parliament, they were not afforded the same opportunity to have their late submission considered. Honourable members, the selective inclusion outside the advertised timeframe may give rise to concerns regarding consistency and equal treatment of similarly situated members of the public, and it is my very respective view and recommendation that members should reconsider the inclusion for oral testimony of these 2 individuals that was previously condoned. Chair, so yeah, that is my story. Just to conclude, to say that the submissions were assessed and selected on the basis of relevant systemic value and the potential contribution to the committee's understanding of governance and accountability challenges, rather than a random or selective basis. Chair and honourable members, as the process unfolded, the way in which public participation was conducted evolved quite significantly, with elements of more structured questioning really necessary. Here, it must be understood that whether presented orally or in written format, all submissions remain an important contextual component of the committee's work and will be considered other information in the committee's deliberation. That is conclusion for this part of the presentation. Honourable Chair, honourable members, if you want me to jump directly into the report writing framework, I can do so.
Yeah, before we go to the framework, I want you to say to the committee, in the report of the public submissions that we gave you, there are the following witnesses that could have appeared before the committee. They didn't, and our recommendation is that the committee must give them chance. I mean, in case there is such a case or there are such cases. And if for instance, on Mr. Chetty, I heard your recommendation that Mr. Chetty is undergoing trial, and it may not be advisable for the committee to give him a chance to appear before it. I thought, for the purpose of easier discussions or discussions which are structured, if you can help the committee in that regard, if there is any case, for instance, that you feel the committee may have to consider it being scheduled for appearance, you just indicate that in this report that I've given you, these are the recommendations I'm making before the committee. Is it possible for you to do that?
Definitely, Chair.
Okay. I'm not putting you under pressure. If you want to reorganize yourself, we can take your next presentation, and then shortly before we take discussions, then you then take us through your recommendations on the public participation report.
Chair, yes, I can do that.
Okay. Are you starting with the recommendations, Nicolette, or you want to present the framework for the report?
Chair, apologies. I think I'm going to start with the report writing framework, if that will be okay.
Okay.
Members, this is really a very short presentation. to just to structure how the different support teams to the committee will support going forward into deliberations. We have a separate report structure that is currently developed and in quite a substantial manner in which the report writing will be structured. It is evolving to some degree in that as we workshop the report, which areas and aspects should be additionally included beyond the scope and terms of reference of the background legal framework. So, Chair, I just want to quickly say here, and the purpose of this document, the framework here, is to clarify what the senior counsel and the contact team will be providing to the committee going into deliberations when they witness appearances are concluded. It is then recommended or proposed that senior counsel, having led the evidence throughout the inquiry, will provide members with a consolidated evidentiary overview prior to the commencement of member deliberations. That this evidentiary overview contain the all evidence before the committee, taking into account oral testimony, sworn statements, documentary material, and expert inputs. It would highlight areas of convergence and divergence between witnesses, stating or showing which witnesses really contradicted each other. And this will be focused on the really the main actors in as part of the inquiry. The senior counsel will draw attention to the material contradictions, credibility concerns, and evidentiary gaps, and identify unresolved factual or institutional questions that require the just judgment from members. So just for the avoidance of doubt, the evidentiary overview will not contain findings, determinations of wrongdoing, or recommendations. The assessment of evidence and the formulation of findings and recommendations remain the exclusive responsibility of the committee. Then moving on to the role of Parliament's content team, and this is including the research unit and the content advisors assigned to the committee. So separate from Council's evidentiary overview, the content team will prepare a thematic analysis report highlighting alignment of the evidence to the terms of reference, identifying governance concerns, and outlining potential parliamentary reform priorities in order to support members during deliberations. The analytic work constitutes part of our formal mandate to support the committee in organizing evidence, structuring deliberations, and facilitating the preparation of a coherent, scope-aligned report. Honourable members, in undertaking this function, the work will be descriptive and organizational in nature, ensuring that evidence is structured without preempting findings, that is aligned to the terms of reference and the anticipated structure of the committee's report, and it is intended to support deliberations and report writing. So this document naturally does not assess credibility, resolve contradictions, or express evaluation judgment. The role of the committee, as members know, I'm just stating here, is the exclusive constitutional function of members of parliament. During the stage or this phase, members will weigh and assess the evidence, evaluate the credibility and significance, determine findings, observations, and recommendations, and exercise parliamentary judgment in fulfillment of the committee's oversight mandate. So members' deliberation are informed by the evidence placed before the committee, the consolidated evidentiary overview presented by senior counsel, and the analysis report from the content team, as I mentioned earlier. Then naturally, members also use any other resources and documents to their disposal, including, as senior counsel mentioned, the transcripts of meetings. So, honorable members and chairperson, just in terms of this sequencing and interrogation of process, the evidence laid before the committee through witnesses and documentary material, members engage with the witnesses on their testimony. Senior counsel presents a consolidated evidentiary overview. The content team submits an analytical report. Members deliberate and determine findings, observations, and recommendations. The content team then draft the committee's report reflecting the outcomes of deliberations, and naturally this will be guided by members of the committee. The committee then adopts its report for tabling before the National Assembly by the end of March. Apologies, it should be the 27th of March, not the 31st. So I just want to give clarity on the distinction between the evidentiary overview and the committee's report. The evidentiary overview prepared by senior counsel and the committee's report serve fundamentally different purposes. The evidentiary overview produces the evidentiary record for prior to deliberations, and the committee's report represents the collective judgment of members adopted by resolution and contains the committee's findings, observations, and recommendations in the exercise of Parliament's oversight authority. Honourable members, that is it from the reporting framework. But like I mentioned earlier, the actual report framework is under development. It is in a very advanced stage. So yeah, members can rest assured that it is receiving significant attention. Thank you, Jane, members.
Thank you, Nicolette. So on this framework that you presented here, how much time do you have for members to submit their inputs?
Chair, we are proposing that directly post the witness appearances. The committee goes into a phase of deliberations, and based on the deliberations, the report will be based on this to ensure that all the the concerns and matters raised by the committee are included, and then will flow into deliberations on the key findings and then naturally the recommendations.
No, I mean on the structure of the report.
Oh, sorry, Chair. Apologies for that.
Not the substantive matters. Let's say on your structure of the report, there is an honorable member who feels that there is one thematic area that they believe must be included on the structure. That's why we said that when you present this framework, this is not the contents of the report. You are saying to members that the final report that we are going to be writing is going to be structured in this way.
Yes.
It will provide for introduction, background, terms of reference, this and that, up until conclusion and recommendations.
Yes, Chair.
And then there is one member who says, but maybe there is one theme that is missing. Can we also include it? I wanted to check how much time do you give members to make inputs on how on the structure of the report.
Chair, let me ask you rather to be led by the committee in that what time frame would the committee be comfortable with? We will be able to deliver, but currently, as we stand now, it is very difficult to provide the information that is requested because we are not completely sure what the deliberations will focus on during.
Yeah, I heard you when you started the presentation. You said this framework is evolving. I think it's a point that members can take home to understand that as it stands now, it may be difficult to say this is a solid framework depending on the nature of evidence that comes in the upcoming proceedings. But for now, with what we have gone through, your proposal is that the report must be structured that way. So members must note the report, the structure, go and look at it. If there are any inputs that they want to make on the structure, they can make those inputs. But that does not preclude that if they have submitted their inputs, if something comes up in the proceedings that are yet to happen, they are not allowed to make further submissions. It's something that is evolving, like you say, from time to time. If members pick up something that a theme or any other important issue that they think may be one of the topics in the report, they are allowed to make such submissions. Am I representing you correctly?
Definitely, Chair. The analytical report that will be produced by the content team will also be, I think, very helpful in identifying what has been, according to our team, the most material areas that was covered by the committee during deliberation or during evidence. The plan is that we submit that report because it is updated as we go along, that this be provided to members within 3 days. 3 days of the conclusion of evidence before the committee. It is quite a substantial document because it summarizes the key points made by all the witnesses identifying key governance concerns, and then also key identified reform priorities for Parliament. But Chair, I think that will really assist if members can have a look at that, and based on that also please give input on how that is structured.
Okay. And then do you want to go back to the recommendations on the public submission report before we rotate for discussion?
Yes, Chair. Yes, Chair.
Yes, you can go ahead.
Chair and honorable members, in front here, we have the previous list that was presented to the committee. So this one does not include the civil society organizations that has already appeared before the committee, like APCOF and ISS, Accountability Now, and Dr. Jean Redpath. What we see here, honorable members, is the names highlighted in yellow as the persons that we are recommending to be re-evaluated by the committee. It does not include the two names and that was submitted by Honorable Souls, and because that doesn't form part of the original list. As members see here, the anonymous submission that I indicated previously, that caused a bit of a confusion during the public participation process. However, it can be made available to members, but it is my respectful view that this can be taken as read. The submission is not in a sworn statement, but it does provide context to the submission. Then the second name for re-evaluation is Councillor Mokgope, where I indicated that there are several ongoing criminal investigations showing that corruption or fear of reporting corruption is not localized at national and provincial, but that it does trickle down to the municipal level. Then we have Mr. Mkhwanazi, and that is a former employee of the State Security Service, which we were advised rather not to take because we are uncertain as to, or it is feared by the team, by us. The SA did not say this, and must be on record. They did not say what I'm saying, but it is a procedural concern that the individual could speak to information that is classified, which is a risk for the committee. Then Mr. Mpofu-Walsh, he is also a very individualized case, showing that corruption is really rife in all divisions of the police. And then Mr. Chetty, that we have discussed, and Dr. Rawls, that withdrew from the process. So, Chair, also I just want to mention in terms of the civil society organizations, we have not heard from this individual because, yeah, there were slight challenges with communication, I want to say. He submitted on the chain of evidence in which he makes policy-orientated recommendations as how to improve the chain of evidence by the police, and that is a key aspect of our terms of reference, but it does not refer specifically to the 121 dockets that was moved. So that is more a overall submission on the handling of evidence by the police. And then, as I indicated, Gun-Free South Africa, their submission really focuses on, it's very interesting, it focuses on previous significant corruption in the police regarding the control of firearms. I think many members know about the Prince Lua case, in which firearms that was destined for destruction was sold back to criminals and used in the Cape Flats to in gang violence. And that has been demonstrated that these are linked. It is evidentiary proof that these firearms were used in murders based on the serial numbers and, ballistic evidence. So, Chair and members, I think it will be very good for Gun-Free South Africa to, if we can maybe have another discussion with him to appear before the committee, because this specific corruption case has significant impact on safety and security. So, yes, Chair, I hope this answers your question in terms of who was originally identified and who
Okay, so you are recommending Gun-Free South Africa for the specific reason that you have mentioned, for them to be considered for appearance.
Yes, yes,
Thank
Chair.
you so much. Thank you so much. Honorable members, I think let's thank Ms. Van Zyl for the comprehensive report. The report on public participation has been very comprehensive, and the recommendation, one outstanding recommendation coming from it is that there are significant matters that are being raised in the presentation of Gun-Free South Africa, which she advises that the committee may have to feature them to appear before it. And with regard to the structure of the report, the structure is made available for members to afford themselves time to go through it and make inputs. And members are not limited in terms of their inputs, because what is fundamental is that the structure of the report is evolving, given the dynamic evidence that will always be presented before, the dynamic nature of evidence that will always be presented before the committee. Those are the recommendations that are being circulated before you. and any other matters that members would have picked from the report and will want to bring them for discussion. Thank you. Can I start the rotation? The ANC. The MKP.
Thank you, Chair. I'm not sure, Chair, whether we must respond on what Nicole has spoken about.
Yes, I'm rotating to you to hear whether you support the recommendations she is making and whether you have any other matters that you want to raise emanating from the report.
Indeed, Chair. I think some other information he gave us is misleading. One, I'm going to, in fact, correct the secretariat that the last person, the public participation person, is the name as well is wrong. I think we will start there. Kitchen Chetty, there's no Christian Chetty. That's number one. Number two, the affidavit of Christian Chetty. I mean, initially we were told that there was a problem of locating him. His phone, he was nowhere to be found. Number two as well was that they contacted him. And the lawyer, I can tell you that he said he was very concerned of what is happening because of what they've deposited here. The matter about this matter was about General Sibiya and IDEC. It had nothing to do with the merit, that is on bail. This matter will be, I mean, he's got lawyers. They'll represent him, in court. That his matter was struck off the roll 4 times. And there were issues. I don't want to go to those merit, Chair. But there's the silver case, the case which was open in 2022 was about the issue of General Sibiya and IDEC. This issue of that there were assets and other issues are irrelevant. They'll sort the lawyers will sort those matters out. In fact, because they knew why was he be out of the 600 or 700 people were chosen. Why was he chosen initially? Now, I think, Chair, as I was saying, that this matter for me, where I'm sitting, that the affidavit is very clear about this matter. Why now they are bringing issues which are irrelevant here? I mean, General Kumalo was on bail. Matala is still in custody.
What is your suggestion?
My suggestion here is that this matter has got nothing to do about these issues which we were told by Nicole. The affidavit is very accurate here about what is the issue. It's a judicial system, magistrates, prosecutors, and curators who are working.
You suggest that the witness must be made to appear before the committee.
Yes.
So
that's my suggestion. And able. Yes. And able. Yes.
You are saying that on top of the recommendation that Gun Free South Africa be featured, you also adding the name. Is it 1 or 2 more witnesses?
For me, I don't know even adding the Gun South Africa. I'm talking about Abel and Mr. Chetty.
Okay, it's fine. We will rotate that and hear what the members are saying. Members, I think you have heard the recommendations from Ms. Van Zyl and further recommendations that Honorable Skhosana is making. The Democratic Alliance.
Chair, thank you. Firstly, I would like to welcome the report by Ms. Van Zyl. Yeah, thank you for that. Chair, I tend to agree that we need to protect the integrity of Parliament. It's important that the process is also respected. All of the relevant dates and everything were communicated timeously. All the relevant advertisements were done. So I don't see any reason for anyone to have really submitted anything after that time. And therefore, I also think that we actually don't have the luxury of time to just continue inviting unnecessary people. I don't want to cause offense to anyone, but somewhere we need to start drawing the line to get this process to a point of completion. Thank you, Chair.
Thank you so much. The EFF.
Thank you, Chair, and thank you, Nicolette, for the comprehensive report. Chair, we just must have it noted that the issue that arose for us to get this detailed report, at no point did we say that we are going to accept submissions with no evidence. The issue here was that we were turning away submissions because they did not give a written, a sworn or a written statement or a sworn written statement. So we said the same way that we are assisting other witnesses, these witnesses must be assisted in going through what it is they are saying they want to tell us. Like how we are assisting witnesses now to do their sworn statements, that must be the same way. We must deal with the public participants and also on compiling their evidence. So the issue there was that we were just excluding people because they didn't give us a sworn statement. So that must be clear. It can't be that we changed gear in the middle of it. We've never ever said that we wanted anyone to appear before us without a sworn statement. We said that they must be assisted. So this is why we are here now. Then the second issue arose that we have this report was because the evidence leaders were saying that they were not getting the sworn statements in time. They were not going through the statements with the witnesses. So literally, during the people, Chair, they were going through the statement and asking. So in terms of the evidence, they said they got the information from our back office on the day or the same time that we got it. So that was just a procedural issue. And it was if the evidence leaders, and that part was done how we had done with all our other witnesses, we wouldn't have had a situation where we had witnesses who hadn't given a proper sworn affidavit and we hadn't gone through the evidence. So I think that must be noted because that is very important, what has brought us here in the first place to get this report. So there just needs to be better synergy between the evidence leaders and the Office of Parliament that is going through the public submissions. The report also says that there was logistical constraints, but it doesn't say who caused the logistical constraints. I think that must be noted, but I don't think that is of most importance. Chair, we've already, as a committee, there was condemnation that we had given. I think it was one was for Honorable Souls and there was one for another. So I don't know why the matter's been brought before us because during our, I think it was not our last meeting, the meeting beforehand, we had agreed as the committee to grant condemnation. So to come back and say that question whether we should have or shouldn't, we should have been done already in that meeting. So I think we must just go ahead. We have done that as a committee. It's a closed deal, and we've also agreed that we are done accepting any more public participation or submissions now. But we had granted condemnation, and that should stand. We can't go back now and say, oh, we granted it under false pretense. I don't see how that is even going to work. And on the issue of Gunfree, we gave them a date to appear. They didn't appear. Our position is that we must just take their written submission. We don't, we'll take their written submission and put that into consideration. We are working on a time time restraints, as we have mentioned. And if they were not available, they didn't even give us a proper reason on why they were not available on the date that we allocated to them. So the least we can do is take their written submission, and obviously we'll include that during our deliberations. And then I agree with Honorable Kekana that we have had most of the people that have appeared before us have active cases. So it can't be a reason that we cannot have someone appear before us because they have an active case. Most of our officials in SAPS have active criminal cases and they appeared before us. We even went to prison to someone who's been charged. So that can't be a reason why we should not consider his or consider him as a witness. And that's the input from the EFF. Thank you, Chair.
Thank you so much, Honorable Sols.
Chair, thank you so much. On the issue of gun-free, I think written submission would suffice. On the issue of the witness that was suggested by or brought forward by Honorable Kekana, I agree with him on that. If our focus is on aligning with procedure, then nothing stops. It's not outside of procedure to have those witnesses come, because we are interested in finding the truth, and whatever can assist us in doing so, we should be open to that. Our emphasis should not be on what disqualifies a person on technicalities. Our focus should be on whether what the person can bring as testimony will assist us in our process. That's where our emphasis should be. Which brings me to the fact that the report by Ms. Van Zyl, as she presented, gives the impression that the committee is inconsistent in our approach with public submissions. I vehemently disagree with that. We didn't shift goalposts. We were very clear about accommodating the public submissions and the support that they must receive. And even oral evidence on their experiences might become evidence on what our terms of reference has mandated us to investigate. So I think that is wrong on the part of the legal team there. Then on the proposals that I've made, I must state very emphatically that it's a direct misrepresentation of the facts. The whole of Section 8. I will zoom into Section 8.8. The issue of the members of the public in question, that they have direct access to me, and that's the reason why they were able to get their issues submitted. That's not how it happened. How it happened was that the sergeant in question, he wrote to the Parliament legal team. He spoke to Bonane. He was called by Bonane and rejected without explanation. So I was not the first point of contact. And then he wrote an email to my official email that the whole of South Africa has access to because it's public. So it's my work email. So there was not some special arrangement. And as a public servant, it is my duty of oversight to then inquire from the committee and for us all to look into the merits of whether this testimony should be considered. And I did that. And ultimately, we decided that indeed it is valid and they should be considered, and a condonation was given. Similarly to Ms. Dimi, they had reached out to media and different people for years on their matter. They did not know about about our deadline. And I merely just read the emails as it was sent, and the committee gave a condonation. Out of desperation, not privilege, they didn't even send me on my work email. By chance, I looked at my messages on TikTok and I saw a message by them to me by chance. And again, as a public servant that is interested in finding the truth, I then responded. And that's how I then brought this to the committee, and the committee decided to condone. Lastly, 8.5 is a clear misrepresentation of facts. They saying, Ms. Van Zyl and the team is saying that there is no record of the claim that the sergeant was mentioned in Mr. Matlala's testimony. Indeed, his name was not mentioned. But in Mr. Matlala's testimony, he said that he was sent to go and negotiate with someone to drop the case. No name was mentioned. That person then comes after the testimony and says, I am that person. Now, for the legal team to reject him first is questionable. When it came to me, in the interest of finding the truth, I thought it was important. If we are after evidence, here is someone that says, I heard the testimony and I want to come and talk about that because that is me whom the witness is talking about. How do we reject them? It is quite hypocritical if we're going to reject it when we are now saying that our framework of report will be evidentiary. Here's evidence or alleged evidence, potential evidence. We must be able to hear it. And that was the motivation. It was not special treatment or special access. It was a drive for the truth. So I wanted to make that very clear. And I will rest there, Chair. And I hope that we are clear that it is not the committee that has shifted functionalities or processes. It is the legal team that has done that, like we are doing now. We want to focus on evidence. We want to get to the truth, but we want to disqualify people on technicalities. And so I don't know these people personally. I just played my role as a parliamentarian and a member of this committee, and because I want to ensure that we maintain the integrity of this committee. So we should uphold the condemnation for these members and not be hypocritical in our approach. Thank you, Chair.
Thank you so much, Honorable Solf. Honorable Vessels.
Thank you, Chairperson. Let me also welcome the presentation and the work that has been done in that regard. Chair, I want to echo the sentiment expressed earlier that we should move towards conclusion. And although we should do everything in our means to get to the truth in this investigation, it will never be possible to get all relevant evidence in front of us. There will have to be a point where we say that certain issues will have to be referred to portfolio committees and other committees of the National Assembly for further investigation and further scrutiny. Having said that, Chairperson, I also agree with other members that said that gun-free South Africa should rather just be considered with regards to a written submission. And I also do agree we did condone certain witnesses as referred to by the Honourable Souls. Yes, and I don't necessarily think we should reevaluate that. We did make a decision, but that's my opinion. Thank you, Chair.
Thank you so much, Honorable James.
Thank you, Chair. Chair, we welcome the report, and I also support the view and input of the DA. Many of these challenges that we're speaking about it now, we've already agreed on it. Thank you, Chair.
Thank you so much. What is that name again, Honorable Skosana? Okay. Honorable Ms. Van Zyl, do you have any? Yeah, hello, Honorable Skosana.
Yes, it's Mr. Chetty, Chair.
Chetty.
Okay.
Thank you.
Ms. Van Zyl, do you have any comments you want to make before I summarize the discussions?
Chair, thank you. I'm covered.
Thank you. Thank you so much. We are going to allow Gun-Free South Africa to make a written submission. And we will include Mr. Chetty on the list of the witnesses. That is the general feeling of the meeting, that Mr. Chetty must be included. That concludes the discussions. And all other decisions that the committee has taken previously, the committee takes ownership of those decisions. They were taken in committee meetings where all of us were present, and there is firm ownership that is established on those decisions. Can we move to the item on correspondences? Is it you, Telana, again, or is Mr. Tejana? Oh, Mr. Tejana, how are you? The correspondences are five, isn't it?
I think about six, Chair. I think about six.
Yeah, can you take them?
Let's see how far can we?
Can you take them? Can you take them? Can you take them three?
Yes, Chairperson. Look, I think let's start with the letter from Weber Wenzel, dated the 11th of February, 2026. Chairperson, my colleague, Ms. Nicolette Van Zyl, has touched on this. If you look at paragraph 7 of a public participation report to the committee. Chairperson, what happened here is that we are dealing with the testimony of Ms. Pelati Machangola, which was given to the committee on the 4th of February 2026. Chairperson, the witness in question was a walk-in. In other words, Chairperson, it was not a question of we were dealing with someone who had been initially selected to be part of this process. I think, Chairperson, through your benevolence, when she interacted with you, you then deemed it fit as a public representative to allow her to speak. But the nub of this correspondence is that harm was visited allegedly on Mr. Themba Mkhwanazi. And Chairperson, we have been informed that Mr. Themba Mkhwanazi is a corporate executive of note. And he is currently establishing his own business, is involved in various commercial transactions, and is frequently asked to apply for non-executive directorship positions. So the issue which his legal representatives are raising is that his professional reputation and credibility are of paramount importance to him. both professional and personal. Now, Chairperson, you will recall that the witness in question had made various allegations against Mr. Mkhwanazi, which even the committee members, including yourself, Chairperson, Honorable Sols, Honorable Nomvalo, Honorable Kosana, when you began to interact with this statement, it was very clear that even the presentation that he was making was entirely outside of the scope of the committee's mandate. And I think, Chairperson, I don't have to go to directly in terms of what you said, what Honorable Kosana said, what Honorable Sol said, and what Honorable Nomvalo said, but I think that sums up the testimony of the day to say that you had someone here who was just here on a frolic, engendering or protecting or ameliorating his personal interests, which had nothing to do with the committee's terms of reference. Now, Chairperson, the legal representatives of Mr. Temba Mkhwanazi submit that whilst the committee's own members challenged Mr. Mkhwanazi's credibility, and the Chairperson ultimately concluded she had abused this platform. That's what you said, Chair. This does not undo the reputational harm caused to Mr. Mkhwanazi by allowing these allegations to be made and recorded in the first place. So, Chairperson, you will see that they raise a lot of procedural irregularities, from failure to properly screen the witness, to failure to require a sworn written statement in advance, failure to confine testimony to matters within the scope, and allowing defamatory allegations to be made before administering oath. So they raise all those things, Chairperson. But at the end, Chair, what they request this committee to do, they are requesting this committee to, at the next public hearing, Chair, which is tomorrow, to issue the following statement. And I quote, the committee records that a witness appeared before it on 4 February 2026 and made allegations against Mr. Temba Mkhwanazi. The committee further records that these allegations were not verified, were unsupported by any credible or admissible evidence, and were found to lack any evidentiary foundation. The committee acknowledges that the allegations fell outside the scope of its terms of reference and did not relate to any matter properly before the committee for investigation or determination. Having considered the matter, the committee records that it does not consider there to be any basis to believe that the allegations made against Mr. Mkhwanazi have substance. In these circumstances, the committee expresses its regret that the allegations were made and recorded during its public proceedings. The committee recognizes that the public nature of its proceedings may have given unwarranted credibility to untested allegations and may have caused harm to Mr. Mkhwanazi's reputation. The committee accordingly issues this statement to correct the public record and to make clear that the allegations should not be relied upon for any purpose. Further to that, Chairperson, they request that same should be provided to Mr. Mkhwanazi with a written letter to the same effect, in other words, with the same wording. And lastly, Chairperson, the committee must ensure that any published transcripts or records of the proceedings include a prominent disclaimer or note indicating that the allegations against Mr. Temba Mkhwanazi were unsubstantiated and outside the committee's scope. Chairperson, our view is that we think that the remedy that they are seeking from the committee is an appropriate one. And we think, Chair, that it is proportionate But Chairperson, regarding whether you agree with us, we are in your hands. But Chairperson, maybe to quote from one sage man who once said, there is no way to peace. There is only peace. Thanks, Chairperson.
And then do we have the letters from the, is it Media 24? Are they seeking similar remedies?
Also, sorry, Chairperson, no, not quite, Chair. So the News 24 one and the Daily Maverick one, all they are saying, Chair, and I refer to them as out letters, all they are saying, Chair, is that the committee should put their side of the story to General Pahlane, given that General Pahlane will be taking the stand on Thursday and Friday. And of course, if General Pahlane cannot adduce evidence to that effect, then General Pahlane must retract those statements or apologize. Failing which, of course, you can't force someone to retract or apologize. The committee will make its own judgment when the time for compiling the report is upon it. So that's the slight difference, Chair. So regarding those ones for News 24 and, Media 24, Chairperson, and Daily Maverick, the relief is that put our version before the witness, and of course the witness must adduce evidence to that effect. And of course, if there's no evidence adduced by the witness must retract and apologize. But as I said, Chairperson, the committee will make its own judgment when compiling the report. Thanks, Chairperson.
Okay. So maybe before I circulate the three correspondences is from Weber Wenzel acting on behalf of Mr. Themba Mkhwanazi. And Daily Maverick and Media 24.
So Daily Maverick, Chairperson, is Pelem de Klerk attorneys acting for Daily Maverick, yes.
Yeah. In the three correspondences, the people who wrote to us, they are aware that all the witnesses were speaking to us under oath.
Correct, Chairperson. That's why Chairperson reference is even made to section 17, 2D and E.
Yeah.
Of the parliament.
And they want us, even before we evaluate the evidence that has been presented before us, to make a judgment that this evidence is not substantiated.
So what's happening, Chairperson, is that if you look at the dates of these letters, you will see that these letters have not been dispatched to General Pahlane and his legal representatives. So what they are suggesting, Chairperson, is that we dispatch these letters to General Pahlane and his legal representatives. And of course, Chairperson, when they appear before the committee, members, as it is their committee, to put these questions to General Pahlane. And of course, General Pahlane has to adduce evidence. And as I've said, Chair, if he fails to do so, as it is in the discretion of the chair and the committee, he must be asked to retract and apologize. And I would imagine, Chair, that some of the witnesses would not take that route.
Yeah.
And therefore, Chairperson, we leave it to your judgment as the committee when you are evaluating General Pahlane's evidence.
Do we have the right to amend or cancel, erase the evidence that a witness has presented before us?
No, Chair, that's not the request. The request, Chair, is that, let me just be practical. In one of the letters, General Pahlane says there was this bribe which was organized in Bedfordview. There was this meeting chaired by Mr. Paul O'Sullivan, and there were various people there. And one of the people who were there is a journalist of Daily Maverick by the name of Miss Marianne Tham. So Miss Marianne Tham disputes that she has ever even attended at the house of Mr. Paul O'Sullivan. So the issue here is that just on that segment of the evidence. So the issue is that General Patlane must be challenged by this committee to adduce evidence. And of course, Chairperson, if he doesn't have it, then it's within the committee's discretion to request him to retract and apologize. And of course, Chair, if he doesn't, without having adduced evidence, then at the end, when you are evaluating his evidence, you will make a judgment call. Thanks, Chairperson.
Yeah, because you know where I stand. Let's say Media 24 or Daily Maverick or Mr. Mkhwanazi themselves. If there is any evidence that has been presented before us as a committee, they cannot write to us and say that evidence must be disregarded. The witnesses appearing before us, they are sworn to oath. What they should say themselves, because there are stated principles in law, before I circulate to members for discussion. There are stated principles in law that both versions of the story must be heard without even us inviting them. If they are indeed worried, they could have themselves made written submissions to say this is what we know about ourselves. But for them to write to us and say, ask Patlane the following questions, we can't do that. And I don't even think that they could be right in their own senses to direct us what they must do. If they have issues with Patlane, they can raise those issues with him. If they have issues with Mrs. Majaule, they can raise those issues with her or whoever has appeared before us. But for them to write to us and say they want us to get a witness to retract certain statements that a witness would have made, that is inappropriate. The relief they seek is inappropriate. And there can never be any judgment that we make without any written submission from them. If they want to state a case to say, no, we have heard the following allegations that have been made against us or against our client or against our associate. To our knowledge, we depose here in this affidavit that this is what we know or this is what we do not know. And the committee will make a consideration. The committee has never got to a session where it considers its report. But if every day South Africans or juristic persons are going to write to us to say, Lahanyane said this about me in the meeting, and the committee must make him to retract, or the committee must make him to apologize, or the committee must write to Themba Mkhwanazi and tell him that the record that was made on that day by Ms. Majaule, that record is not substantiated. I don't think that is procedurally fair. But let me rotate to members and hear what the members are saying. The African National Congress. the MKP.
Thank you, Chair. I think, Chair, you sum it up by saying we can't be dictated here. You know, your Mariam Tam, Karen Morgan, Anton Passon, whoever, you know, they can't tell us how to do our job here. I mean, they know, Stratcom knows exactly, you know, what they are writing about other people. You know, if they feel strongly, as you said, they must deposit as well here. You know, but for them to say that they are untouchable, there's no one who's untouchable. We are trying here to probe and we want to get the truth of the matter from anyone. We are not a court of law. You know, but the issue that they are raising here, they want to protect and hide things. You know, that time is gone, Chair. We need to make sure that we dig deeper, you know, irrespective whether it's Media 24 or Amapungan or whatever, Chair. So in my view, these letters, for me, are like love letters. Thank you, Chair.
The Democratic Alliance.
Thank you, Chair. Good afternoon. Chair, I disagree somewhat with the views stated previously. These are letters asking us to ask the witnesses when they return to present evidence. We should be asking our witnesses to present evidence, and a lot of people have said a lot of things. They're purely hearsay and has no evidential value. So there will be no harm in asking the witnesses to produce evidence. It's not for us to ask them to retract, but certainly it is for us to ask them to produce evidence, and if they can't, then we'll draw our own conclusions from that. So I see no difficulty in asking them to produce evidence. Thank you, Chair.
The EFF.
Thank you, Chair. I support
discretion, the exercise of your discretion to allow the member of the public to provide evidence, to portray it as negligent, number one, and then to make it look like because of such a negligent act, the result is that we had a witness that was concluded not to have been credible. And then to create the impression that if she was not negligently allowed, we wouldn't have had this claim of reputational damage. I think that's wrong. I think it is the other way around to say that in line with our terms of reference, the chair was correct to have a woman that's been sitting there for 2 days to hear her out and then make a decision to say, let's allow, and then that is in itself public participation. And ultimately, after interrogation, the committee, who has done an excellent job in determining that what she put forward, in our view, was not credible. The person involved, Mr. Mkhwanazi and others, has the right to then seek other remedial mechanisms to deal with what they would consider false allegations. And on our side, as the committee, our conclusion on her testimony will be in our report ultimately. And his attorneys can then use that conclusion that we make in the final report on her testimony as evidence or as support to say that it was reputational damage, etc., and the committee did not find it credible. But to now expect the committee and the chairperson to sort of take responsibility and make it look like the integrity of the committee is now in question and that of the chair, I think that's the wrong approach to take. So I stand with you on this one, Chair. Thank you.
Thank you so much, Honorable Vessels.
Thank you, Chairperson. I agree. I think, as you also put it, we have the principle of natural justice in our rule of law, and everybody has the right to be heard when they are accused of something. It is difficult. I heard what you said, that people then had the right to also make submissions. But obviously, they at that stage didn't necessarily know that they were going to be mentioned, some of them. But Chairperson, I think we take note of what these letters say, but I do agree that we can't be instructed to do anything. And at the end of the day, the Honourable Souls is also correct that if perjury was committed in the view of these entities and individual, then they have remedial action to they can take certain remedial action, and I don't think that the committee should be forced to do anything. Someone has the right to defend their good name and their reputation if they feel that they are being slandered and that they feel that the facts differ. But that does not influence. We scrutinize the testimony, we look at the evidence, and we'll make conclusions in the report. So I think that's how this should be dealt with. Thank you, Chair.
Thank you so much, Honorable Vessels. Honorable James.
Thank you, Chair. Chair, I want to say that let's not be too arrogant in terms of how we respond to these media houses. There's absolutely nothing wrong with their request. I think we serve all South Africans, so we shouldn't see it as if though they are dictating to us. There are people who ask us questions who actually does not understand how things actually works in Parliament and our responsibility. I think the response you made, Chair, going in depth, explaining the other avenues that's available to them, I think that is appreciated. I think your response was suffice and it addresses their concerns and their challenges, And it also allows them to continue taking up this matter in other relevant spaces as well. So I think for us, I want to disagree right now. We have said as Action SA, I think from the onset, we needed a forensic investigator to test the evidence. For us to now say, there's no harm in asking all of these witnesses now, because at which point are we going to call it a day for evidence? We then should have done that at the very beginning, because everyone came here and ran their mouth and said everything, and it is up to us to decide, where the truth actually lies. I think your response, Chair, to this is suffice, and it is appreciated, especially the manner in which you put it. Thank you.
Thank you so much, honorable members. Not a single one of us has been afforded an opportunity to ask General Phahlane questions. General Phahlane is still going to come back before this committee. Number one, he's going to conclude the presentation of evidence. And number two, members are going to be afforded an opportunity to ask General Phahlane questions. Throughout the proceedings, if there is a witness, when there was a witness who appeared before the committee, members have always been saying, what evidence do you have? And witnesses will come and say, I have this annexure, I have this and that. So members are at liberty to ask a witness or witnesses any question that they think will help us to realize the terms of reference that we have set. And Honorable Breitenbach is right when she says it is our work to look for evidence. That opportunity will come. We will ask General Phahlane in the same way as Mr. Nkabinde was here and he made similar allegations about that meeting which happened. And Mr. Paul O'Sullivan said it was a bribe. And Mr. Paul O'Sullivan must also be asked. It must not be like we are only asking General Phahlane or Mr. Nkabinde. Mr. Paul O'Sullivan must also be asked, because the allegations are made about an occurrence where he was also involved. So we will probe those matters. But what the members are saying is that in as much as every citizen, any juristic person has a right to a good name or has a right to information following proper and available channels of access to information, the Parliament must not be seen instructed. We will be a captured ad hoc committee if before we go to ask Mr. Phatlane's questions, already we are advised, let me not use the word instructed, we are advised by somebody in a formal way to say, when he comes before you, can you please ask the following? I don't think that the letter was ill-timed. Maybe those institutions, they could have written to us after members of Parliament have had an opportunity to ask General Phahlane questions and said, we followed your proceedings, we observed the following shortcomings, and we feel that you could have done the following. But even themselves, for instance, if they feel that in the same way as they wrote letters to us, if they feel that there is any information they may want to share with the committee, especially that they feel like they are affected, they can still write to us and say, these are our written submissions, because our names were mentioned by the witnesses that came before you. But we should be wary of a situation where every time we sit in a committee meeting, people will have a flurry of letters and submissions. People say, no, this person cannot say this and that about me. I want this person to retract. I want this person to do this and that. Furthermore, these are not decisions of the committee. The committee is yet to consider its report. A record of proceedings of this committee, like Honorable Mathis has said that, look, I might not have been in the meeting, but it's like there is not even an iota of evidence that is there to be considered. It is at that stage when the committee would have considered its report and concluded to say, this is the final report that we're tabling before Parliament, that somebody can come and say, like for instance, if you remember when we started, Mr. Tejana said at some point that if there are people against whom adverse findings are going to be made, it is only fair. It's a procedural matter that you alert them that we are going to table a report of the committee in Parliament. The following adverse findings have been made, and the person, if they want to make any comments on that finding, they can make a comment, even if they cannot change the finding, but they can always be given an opportunity to make a comment. But I can tell you it will be very, very preposterous for us that we should be found every week writing letters to institutions, to citizens to say, don't worry where you are sitting, the evidence that has been presented about you here is unsubstantiated, and we look, we will not even consider. It's like we must commit ourselves even before we consider a report that, no, don't worry, mister, there is nothing about you. We can't do those things. And Honorable Sol says it here that as a committee of Parliament, the reason why we read that oath and talk about the immunities, the privileges, and everything is because by law, we ourselves as Parliament and its institutions, we must be protected from whatever statements that the witness will be making before us. The witness must know that they themselves take ownership of whatever they say, and they are even warned that whatever you say before this committee, which is inaccurate or which is falsified, may amount to perjury. So all those remedial processes are outlined in our law, and I don't think that it's something that must rattle us. And I agree with you, Honorable James, that when we respond to these institutions, there is no war talk. We have a civic duty to educate our citizens about their rights. We have a civic duty to expand the horizons of democracy education in our communities, in our citizens. We will write to them in a very humble and mature language, and even open ourselves to engagement with them anytime they feel like there is something they want to share with us. They can always do so. So I don't think there will be any problem. We will moderate the language that we use when we write those responses. Is that okay, honorable members? May we move to the next item?
Do you want me to come in, Chairperson?
Yes, Mr. Tejana.
Thanks, Chairperson. Chairperson, the next correspondence is from Lieutenant General Hilda Tumule regarding her appearance before the committee. So, Major General Maga van Rooyen, who is the head of legal services at SAPS, addressed a correspondence to Mr. Rahman on 18 February 2026, in which she expressed her commitment to cooperate fully with the committee. However, she requested, if possible, that she be allowed to respond to any questions in writing. In amplification of her request, she submits that her affidavit deposed at the Madlanga Commission is also available to the committee. Furthermore, Major General van Rooyen also says that General Tumule has also been made aware that she may be recalled at short notice to the Madlanga Commission. General Tumule therefore requests that her submission be considered by the committee. So the nub of the issue, Chair, is that she requests that the committee allows her to submit a written submission as opposed to coming in person. Honorable Chairperson, we leave this request to the wisdom of the members of this committee. Thanks.
So this letter is a letter of two senior police officials. It's General Tumule and General van Rooyen.
No. General van Rooyen, Chair, is the head of legal services. So General van Rooyen writes on behalf of Lieutenant General Tumule.
Oh, okay. No, I understand.
Yeah.
So General Tumule is saying that if the committee so feels, she can appear. I mean, she can write written submissions. I mean, she can make written submissions. Okay. And then do we have other correspondence?
Yes, Chairperson. Actually, you can feel I'm running out of steam now. Chair, there's a correspondence we received from the National Director of Public Prosecution regarding the Mr. O'Sullivan's case, Chairperson, the 2017 one, in which he was charged with Miss Trent, together with two officers of IPIC. Chair, at our last committee meeting of the 9th of February 2026, members had requested that we should write to the NDPP regarding the 2017 case against Mr. O'Sullivan and others. Chairperson, we duly complied, and the NDPP replied to our correspondence on the 18th of February 2026. Primarily, our question was, why was a decision taken by the NPA at the time to hold over the decision to prosecute Mr. O'Sullivan until the matter against General Pathani is finalized? The current NDPP advocate, Andy Mutili, has responded, and his response, Chairperson, is self-explanatory. But Chairperson, if you look at paragraph 2.1.2 of the letter, he says that the POCA, which is Prevention of Organized Crime Act, the POCA requires that racketeering charges require authorization of the National Director of Public Prosecutions. But this Chairperson doesn't speak to other charges which Mr. O'Sullivan and his co-accused were facing. And then 2.13 Chair says, after due consideration of the said charges, the supervisor held the view that there was insufficient evidence to prosecute on racketeering. The prosecutor was directed to reconsider the appropriate charges. Now, Chairperson, we don't get what happened. We don't get the periodization. In other words, the period within which these things happened. And then he says the decision by the prosecutor was thereafter delayed. Again, there's no periodization. Mr. O'Sullivan allegedly defamed the prosecutor, and the prosecutor also had to justify allegations made by Mr. Robert McBride at the Zondo Commission. And then 2.15 Chairperson says the prosecutor has resigned from the National Prosecuting Authority. Now, this prosecutor, Chair, is Advocate Mashugha. If you looked at the witnessed schedule, Chair, you will see that Advocate Mashugha will be appearing before this committee on the 10th to brief the committee fully on what transpired in this matter. And Chairperson, you will know that in terms of the National Prosecuting Act, Section 41, subsection 6, Advocate Mashugha can only do so if he has got a written permission or authorization from the NTPP. So, Chairperson, on Friday, 20th April 2026, the NTPP wrote to you in which he agreed to grant the written authorization to Advocate Mashugha. And I think, Chairperson, all these questions will then be asked to Advocate Michael Mashugha. We have already written to him. He has agreed to be of assistance to the committee. If you look at, there's a question, Chair, which Honorable Sauls asked. I still remember. And that question was about whether the report that was supposed to be compiled by the prosecutor within 7 days of the judgment did serve before the Director of Public Prosecutions. And I think, Chair, in his response, the NTPP has said a report can only become relevant when the delay causing the striking of the matter has been addressed. So which means, Chair, this matter has not moved since the 8th of November 2027. And in reply, he says there was no formal report, as it will only become relevant when it is considered to re-enroll the matter. And then the NTPP Chair says that the ADPP, Acting Director of Public Prosecution, has established that the docket is with the counsel appointed in the civil case and will be assigned to a suitably experienced prosecutor to consider whether to institute a prosecution and whether the case can proceed against Mr. O'Sullivan. Chairperson, let me rest.
Before you leave it there, is there, in their response, is there anywhere where the NDPP or the prosecutorial services explain what informed their decision to say the matter will only come after General Phatlhane's case has been? Why, for instance, was General Phatlhane's case a precondition for them to prosecute the case of Mr. Paul O'Sullivan? Do they provide any explanation?
No, sir, that's what makes the response unsatisfactory.
Okay. When you were saying that the response is unsatisfactory, you were alluding to point like that one where they do not explain their decision, why there was a precondition to say this case will only be handled after the case of Mr. Phatlhane has been concluded.
That's correct.
Okay. You should also be having the last correspondence from Stats SA about that witness who was supposed to have appeared before us and did not have a permission.
No, Chairperson. Look, I recall that there was a letter addressed. In fact, it was not addressed to you, because remember, Chair, Mr. Mashugbuka was the requester. And then what the, I think it was the DG of Intelligence did, Chair, as a courtesy.
Let me help you.
Okay.
What the DG of Intelligence did is that he wrote to us and said Mr. Mashukuka could not appear us because there were certain provisions of the relevant law that were preventing him to appear before permission. And then through the legal counsel, we said it is not for the DG of SSA to write to us. They must write to him because they say they have authority over him, whether as their employee or as ex-employee. And then what they did, they sent us a copy of a letter which they wrote to him to remind him that as their ex-employee, he must seek permission from them. So that correspondence is supposed to be before this committee for noting, to say that we will wait to hear from Mr. Mashukuka at the time when he would have returned to his previous employers to seek permission. For instance, if he writes to them and says, I request permission to appear before the committee, they grant him that permission, he will come here in the same way as Advocate Mashoga has been granted permission by the NDPP. And in the event they don't grant him permission, he can send us the response that they gave to him, and then we solicit reasons from them why they did not grant him that permission. And if their reasons are valid, the committee can say they are valid. And if the committee is not happy with their reasons, the committee can say, we're not happy, and they will find a way to improve on their response to him. But for now, the committee must know that the reason why he may not appear is that he must follow that procedure of applying to the DG of SSA. The letter that the DG wrote to Mr. Mashukuka has been forwarded to the committee as a proof that indeed the would-be witness has been informed that he can only appear before you after he shall have applied for permission. Do you have that correspondence with you?
The DG of SSA has responded to Mr. Mashukuka. Sure, you will recall that this is a matter between Mr. Mashukuka and his erstwhile employer. And what happened here is that when he wrote to them, we were not privy to that correspondence as we should, because that's a matter between him and his erstwhile employer. So they've responded, but they've responded to a correspondence that we didn't have sight of. So we can't comment on that. Safe to say, Chairperson, they declined to grant him the written authorization because they are saying that what served before them does not even meet the requirement of a request within the four corners of the Act. So Chair, we will be talking about something that we haven't seen. All we know is that as a courtesy, when they responded to him, you were copied. We did not have sight of what Mr. Mashukuka wrote when he requested the said written permission. Thanks, Chairperson.
Yeah. What we were copied is not their response to him. What we were copied, or what was sent to us, is a letter that was informing him that if he has to go and appear before the committee, he knows the procedure that he must apply to them.
No, Chairperson. Maybe you've been overtaken, Chairperson, by events. They've responded, Chairperson, and they've declined his request.
Okay. Okay. So there are those three correspondences, honorable members. The first one is that one written by Head of Legal Services at the SAPS, Major General Van Rooyen. Let's forget about General Van Rooyen, and then title this as the letter from General Sintumule, who is a witness that the committee has identified, where the witness is saying that she's aware that the committee has decided that she must be one of the witnesses, and she has made a statement at the commission, the Matanga Commission, which she is prepared to have it available for the committee, which can also be addressed to the committee like we did with the statement of General Mkhwanazi. And then the committee can decide whether it wants to invite her to appear physically, or the committee can make written submissions. I think the legal team can also advise, because I don't think any of us would have seen the statement by now. And then secondly, we have that response from the NPA, which Mr. Tejana has spoken to, that they have responded. Of course, they have given Advocate Mashura permission to appear before the committee to explain how those charges or the matters were handled before court. I think Advocate Mashura would have been a presiding officer on that matter. The NDPP has given him or her permission to appear before us. But further than that, there are other matters, decisions that would have been taken by the Director of Public Prosecutions at the respective level, not to prosecute the case until the matter that was before courts of General Patani was concluded, and it was used as a precondition. And what Mr. Tejana says to us is that in their letter that they responded to us, they have not comprehensively covered the issues that the committee has raised with them. There is a response, but the response is not satisfactory. And then the last letter would be the letter of Mr. Mashukuka, who was supposed to have appeared before the committee. And then the former employer states as a state security agents wrote to him to inform him that he must seek permission from them. So he further reports that they have declined that request, but of course, the witness has not come back to us formally to inform us that I made a request for permission and that request has been declined. So I'm now going to circulate, to rotate those matters for discussions. The African National Congress. The MKP. The DA.
Sorry, Chair, could you please repeat your question? Somebody rang my doorbell while you were talking and my dogs made a big noise.
No, I'm saying that. Hello, Honorable Skosana, do you want to? Hello? No, Honorable Breitenbach, what I'm saying is that there are 3 correspondences that have been presented before the committee. The first one is a letter from General Sintumule. It's one of the witnesses that has been identified by the committee. She's featured to appear before the committee, I think, on the 2nd week, together with General Musikidi. And then what her plea to the committee is that she has appeared before the Madlanga Commission, and her statement can be available before the committee. And she feels that having seen her statement, the committee can be comfortable with her making written submissions. That is the request that she is making. And then I don't know how long the statement is, because I also know we had similar discussion about General Musikidi, if I'm not mistaken, where the senior counsel advised us that her statement is about 10 or 12 pages. And then the second correspondence is from the NDPP Advocate Mutibi, that permission has been granted to Advocate Mashura to appear before the committee. Advocate Mashura was apparently the presiding officer on those cases that involved Mr. Paul O'Sullivan, which the committee wanted to know what happened. So Advocate Mashura has been allocated a day on the schedule that has been presented earlier in the afternoon. But furthermore, there were the letter that the NDPP wrote to the committee, giving further explanation on the matters of Paul O'Sullivan. The sense that we get from the parliamentary legal team is that the explanation is not satisfactory. So we want to hear what the comment of the committee is. And the third and the last of the correspondences is a state security agency, where they wrote a letter to Mr. Mashukuta, informing him that if he is to appear before the committee, by virtue of him being the ex-employee of the institution, he has to seek permission from them. So Mr. Tejana reports that the potential witness had already returned to SSA, and apparently the request was declined. But the potential witness has not come back to us to inform us that he wrote and his request was declined. So we will wait for him until he reports back to us that his request was declined. And if there is any way the committee can help, the committee will do so if the law permits. And if there is no way we can help, hard luck. So I'm saying I'm circulating these matters to hear the comments of the members.
Thank you very much, Chair. I'm sorry to have to ask you to have repeated all that. So I have no difficulty with the first request. Let us read the submissions to the Madlanga Commission, and then we can take a decision. In all probability, we will be able to take it as read. I'm sure that the evidence is comprehensive, but the committee will take the decision once we've read the document. So, and it will probably be quite a big document. So, you know, the sooner we get it and start reading, the better. As far as the NPA matter is concerned, Mr. Mashoba was not the presiding officer, Chair, he was the prosecutor. And yes, he will be able to help us clear up any inconsistencies or any lack of information that there is with regards to Advocate Matibi's correspondence. One must be reminded that Mr. Matibi is both new and has to rely on information supplied to him by other people. Mr. Mashoba has first-hand information. He's the correct person to ask. So when he comes, we should be able to clear up all of the issues that we may or may not have with that matter. So that's fine. And with regards to the third issue, yeah, Chair, I agree. Let us see if let's wait to hear from him. If we can be helpful, we should be. And if it's something that we're precluded from getting involved in, well, then as you say, that's it. Thank you.
Thank you so much. The EFF.
Chair, before?
Yeah, no, it's fine. Let's hear the EFF.
Come back to me. Thank you. Thank you, Chair.
Yeah, we will come back to you because at the time we called you, you had gone to Parliament. So we will come back to you. The EFF.
Thank you, Chair. In terms of the written statement that was presented to the Commission, we can accept it, but they just need to address it and do the necessary changes that is addressed to the Ad Hoc Committee. And then we'll make a decision on whether we need to have her as the oral witness. But I don't think we must take a statement. I mean, we went back and forth on this with Lt Gen Mkhwanazi. So whatever comes to the committee must be addressed to the committee. It can't be a byproduct of another platform. In terms of the NPA witness, I guess we'll be able to, as Honourable Breitenberg indicated, get clarity when they appear before us, and then if not, we can always follow up with correspondence again. The SSA witness, does this also include if we take him as a witness in camera? Or is it no at all to make an appearance before the committee, whether it's in camera or not? Because maybe that's something we should consider. Chair?
I'm sorry, Honourable Member, I was muted. I think it's a matter which the legal team can advise us on.
Oh, okay.
No, Chair, look, it's not about an in-camera, Chair, or not, but he has to get a authorization from his erstwhile employer.
Okay. So we'll wait to hear from him, and then we must be able to give whatever support we can. It can't be, Chair, that we're unable to get evidence on a matter because an act blocks someone from providing that information, even in camera. But let's look at it. We'll leave it with the legal team, and we'll wait for the outcome or the letter from him, or the correspondence from him, rather, on what position he's going to take.
Okay. Thank you so much, Honourable Matthews. Honourable Sols.
Chair, on General Semantemula, I think written is fine, and then we can consider thereafter. The issue on the SSA rejection for the witness to testify, one would think that the natural response to the rejection or the decline would be that the witness now feels that what's the use of further engagement when he was declined, and when he was before us, it was made clear that him giving testimony is dependent on whether or not he is approved. And now that he's been declined, I think he just feels, I wouldn't know, but I'm just assuming that he just feels what's the use continuing to engage. So if that assumption bears merit, then maybe now that we know that he's been declined, and he, instead of waiting for him to respond to us, let us write to him and let him know that we know, and then hear from him what is it that his expectation is, and then see whether there is a way that we can assist. And then lastly, it is good that the advocate is coming to testify, that was involved in the matter with Paulo Sullivan. That's very good. So it will give us some detail on what happened. Just on the issue of the report, Chair, the question that I asked the last time, I heard the response from legal that because of further delays, that report is not available, or my understanding is that it has not even been drafted. But the reason why I asked or spoke about it is because in the information that was given to us, the documentation that was given to us, I obviously have no understanding of these terms or documents. I'll depend on the experts. But what I read, and I'm still having it in front of me here, the nature of that order 342A, section 342A order in the Criminal Procedure Act. The magistrate ordered that on the basis of within 7 days, the state had to explain why it delayed up until that point, that now served as the reason for that case to be struck off the roll. So it appears, and again, clarity can be given to me so that I understand properly, but from my reading, it appears that the court was saying, you delayed until this point, and as a result of that delay, this matter is now struck off the roll. So the state must then do a report within 7 days to the Director of Public Prosecutions, explaining what the reasons for the delays was. And it is that stirred my interest to say that report will give some indication of what the reasons for the delays was. So I just want clarity there, Chair, on whether is my understanding correct, or is it as put here now that the report is not there, it hasn't been done as the magistrate ordered because there was further delays, or was the report to explain the delays up until that point? Thank you, Chair.
Okay, let's hear the comments of Honorable Vessels and Honorable James. I will allow the legal team, Honorable Souls, to clarify the matters that you raise.
Thank you, Chairperson. With regards to the first issue, no problem with the giving regard to the written submission and then taking decisions on that. The second issue, I also don't have any input on. The third issue with regards to the NPA witness, if I understood the feedback correctly, the disapproval by SSA was only based on the fact that he only sent a WhatsApp to seek approval, and that's not the correct format. So it's a format issue. It's not a substantial issue. SSA has not declined, as I understood, his request based on substance. So maybe just to get clarity on that, that's why I understood it, and that's why he should now seek approval in the correct format and then take it from there. If I'm mistaken, we should just be clarified. But that's my input. Thank you, Chair.
Thank you, Honorable Vessels. Honorable James.
Thank you, Chair. Chair, on the first issue pertaining to General Sentimula, I think we need to be thorough and consistent. And before we can actually maybe take a decision on whether we'll accept a written statement, let's maybe first look at the weight of her statement and what is in there. We need to remember that this is I think she's a deputy national commissioner. This is a deputy national commissioner. I think some of the allegations was pertaining to the instruction to collecting those dockets from General Mkhwanazi, if my memory serves me right. So I think let's look. I'm not sure.
She's under General Sibia's line of authority.
Yeah.
Her position reports to that of General Sibia.
Yeah, so she's quite senior within SAPS. I think her name came up from the very first witness that appeared. And we have no problem, as actually say, getting a written statement. But before we can conclude and to say that, let's wait on the statement first, read it, see what it's linked to, and then make a decision. So that's pertaining to her. With regards to the NPA matter, ek moet nog my kop hier omkry. I'm not sure, I can't give input on this as I don't have a complete understanding of how things are actually working right here. So I need to do a little bit of research there. With regards to the witness, the SSA witness, let's wait to hear from him. We've also been thinking, what if he's been deliberately stopped in terms of appearing before the committee. But let's wait for his correspondence to us and we look at why he was actually granted permission in the first place before he was stopped, and we'll take it from there. Thank you, Chair.
Okay. Honorable Skotana, you have the last. Okay. Mr. Tejana.
Do you hear me, Chair? Do you hear me, Chair?
Yes.
Thank you. Thank you. Chair, I think it's a matter of network. I have not vanished, Chair. The issue two, the first one, let me agree with the issue that perhaps the issue of two generals, Musikili and Sintumeling, I agree with the issue that they can send a written, unless there's any other thing, which we will get there. But I guess that it's enough for us to have that. As Musikili, remember the issue of the first the department when he was electing, yeah. And I think is the acting DNC now, where CBI used to be, which is true. But I think the written submission would be suffice. And number two, the issue of the agreeing. I want to welcome that at least
honorable member, we are struggling to hear you.
For once who will give us some information about toll
honorable
other issues as well, not necessarily judiciary was cited, so I want to really appear before us. Network. Yeah, what I'm saying is I hear you, Chair.
Yeah, this is the only time that we can hear you. All the time when you spoke, we couldn't hear you.
Oh, let me just be quick then, Chair, before the network fails me again. I'm saying I agree with the issue of the advocate that at least we'll have one prosecutor. And then the other one that I agree with the issue of the two general sending a written statement. Number three, the issue of the which Honorable Wessel said that the only problem which the other gentleman who came before us, who used to work for SSA, only send WhatsApp. Perhaps if he has to be helped, if he needs help, for him to do the writing and make that application, because we need to know exactly what he wants to tell the committee and the country at large. Because I was afraid that, even if he wants to get married or when he passed on or whatever happened, he must go and get a written, approval. He will need a written approval from the DG. I don't think it's fair. Hopefully, he will do the writing now and write, and perhaps the response from the DG will be positive. I thank you, Chair.
Okay, thank you so much. Mr. Tejana, did you hear the questions that Honorable Souls, Honorable Vessels, and Honorable James wanted them to be clarified?
Chair, look, I think I had the one from Honorable Souls, but I think I missed Honorable Vessels and Honorable James. Chair, what I can say, Chair, is that if you look at the NTPP letter, Chair, particularly paragraph 2.23, what it says, Chairperson, is that the report itself, Chair, was about explaining the causes of the delay. And then what? Sorry, there's interference. Telana, I think Telana is interfering now. Telana, switch off your mic. Telana, could you please switch off your mic? Okay, thanks. So, Chairperson, what I'm saying is that, remember, Chair, the last day that this matter was before court was on the 8th of November, 2017. So the assumption was that, Chairperson, when they come back a week later, there will be a report, which of course, as part of the report, will be explaining the causes of the delay. Now, if you look at 2.23, it says a report will only become relevant when the delay causing the striking of the matter has been addressed. So, and then it says at the end, there was no formal report, as it will only become relevant when it is considered to re-enroll the matter. So which means even the issue of re-enrolling the matter was not given to consideration. But I think what Honorable President Park said, that given that Advocate Mashruga will be appearing before the committee, he is the person who will shed light on this matter. I'm not sure if I've answered Honorable Souls.
Okay. Honorable Vessels. Mr. Tejana says he has not heard your question.
No, thank you, Chair. My question was just if I heard correctly that he said that the reason that the SSA declined the approval for the witness to appear was that the application was in terms or in the form of a WhatsApp, and that's according to SSA not the applicable format in accordance to the Act. So if it's just formative and not substantial, that's how I understood him. He can just say if that is correct.
Mr. Tejana?
Hi, Chairperson. Yes, Chairperson. So, Chair, what happened is this. When Mr. Mashruga submitted, his application to the DG of SSA, we were not copied in that application. So we don't know, Chairperson, what he wrote there. The only thing that happened is when they responded to him, we were just given the courtesy of being copied in their response. So the response merely says that even what he wrote to them does not even fall under the category of, strictly and legally speaking, of a request, I mean, in terms of the act. So the issue is this, Honorable Vessels. We don't even know, I mean, what he put in when he wrote to them and so on and so on. We can only know that if he can come back to us and of course, if we can have sight of his correspondence.
Okay. Honorable James.
No, Chair, I think I'm fine. I didn't ask a question. I just was trying to remember what the allegations were basically against General Sentimule. So I'm covered. I just said that let's wait to get a statement. I don't think there's much there, and let's take a decision at that point.
Okay.
Thanks.
Honorable members, the summary is as follows. The
Chair.
request, Honorable Matthews.
Sorry, it's just on the NPA matter. Chair, can we make a decision that we contact him directly instead of just waiting? I mean, by now I would have thought that the legal office would have asked or contacted him to ask him what exactly was the request, so we would have a more comprehensive report on what it is that he requested. So can we make contact with him, and in the next meeting we are able
state security agents.
Yes, please, because we can't be waiting.
Not
Yeah.
NPA. Not NPA.
Oh,
You
sorry,
say
yes, not NPA. I beg your pardon, Chair. Thank you for the correction. Yeah, the State Security Agency. So let's make contact with him and ask him what's going on. It doesn't make any sense that we wait and we have an incomplete report before us. Thank you, Chair.
Okay. Okay, thank you so much. Honorable members, hello.
No, Chair, I thought you would come back to me and ask if I...
Yeah.
Clear.
Yeah, no, you are very much within your rights, Honorable Souls. You are allowed.
Chair, let me first say thank you to legal for indulging me on this. I just want confirmation that my reading of this thing is incorrect. The section 2.2.3, again, my reading in my mind, it is a report will only become relevant when the delay causing the striking of the matter has been addressed. In other words, what that sounds like to me is the magistrate gives an order to say that a report must be done within 7 days explaining what caused the delay. Now, when this report is there, then another report is required before enrollment. And that report is dependent on the investigation to be finalized on what has been said in the previous report caused the delay. You see, because it says the delay causing the striking of the matter has been addressed. So we then have information as to what caused the delay. Now, what caused the delay has to be addressed. Then the following report, after it has been addressed, will then be used to then seek re-enrollment or whatever. That's how I read it. I just want confirmation that my reading is not correct, and why.
Honorable Mr. Tejana, thank you so much, Honorable Souls.
Yeah, maybe I'm not good in explaining, but what I can say is that no report was submitted as per the magistrate's order. I think I can't take it further than that. So there was no report that was submitted.
Yes, I agree, Mr. Dejana. I'm asking, should there have been a report then? Because then, then that also becomes a question, you see, when the advocate appears or when we deal with the matter, then it becomes a material question to say, why wasn't the magistrate's order followed through on? Because there was a requirement. So that in itself then serves as interference. So that's my thought pattern. So I'm just needing assistance to confirm my understanding is either correct or it's not correct.
Yeah, Mr. Sols. Look, I think, Mr. Sols, I can only say we will put that question to Mr. Mashukha, because Mr. Mashukha was the prosecutor responsible for this matter.
Okay, my leader. Thanks.
Yeah.
Thank you, Chair, for your indulgence.
Thank you so much, Honorable Sols and Mr. Tejana for that clarity. We will forward. Okay, we will advise the legal team to get the statement of General Sintumule. And what the members are saying is that the statement must be a statement that is addressed to the Ad Hoc Committee. And then the legal team will make an assessment of that statement and will then make a determination whether we can seek written submissions. And I know General Msikiri has not made that request, but I heard Honorable Skosana saying it that maybe the legal team can also assess the statement of General.
Priska, I'm talking to you.
Yeah. Honorable Breitenbach. I heard Honorable Skosana saying that the legal team may also be requested to make an assessment of the statement of General Msikiri. And we can be given a report of the legal team, whether those two can make written submissions or not. And with regard to the matter of the NPA, we agree that Advocate Mashura will come here. But the questions that members have now, we will carry them on our sleeves to check if the appearance of Advocate Mashura is able to clarify the questions that the committee has. So it means if that appearance, we may find that there were superiors who should be answerable or who should account on what happened. It means we will go back for further interaction with the prosecuting authority until these answers are provided. And then the last is with regard to Mr. Mashukuta. I think what our secretariat must do, because the only confirmation that we have written are those letters from SSA that were saying that they are providing proof that they wrote to him to inform him that if he has to appear before us, he needs to seek permission from them. What our secretariat should do is to make a follow-up with him, whether he wrote to request for permission, and also the question that Honorable Vessels raised were how, what was the format of his letter, whether he just wrote an SMS or a WhatsApp message or a formal letter, which could have been the basis why his request was declined, or if there is any substantive reasons why his request would have been declined. So if we can make that follow-up and know from him if there has been any initiative on his part to request, and if there is a response what the response has been. And then the report will come to the committee. So that concludes the item on the correspondences, the 6 correspondences that we
No,
had.
Chair. No, Chair, it doesn't.
Do we still have other correspondence?
Correct.
What is that one?
It's from Mr. Paul O'Sullivan. And
Okay.
so what happened, Chair, you'll recall on the 11th.
Is it the last correspondence or we still
Yes.
have?
No, it's the last one.
Okay.
Do you want me to proceed, Chairperson, about it?
Yes.
Chair, perhaps before I forget, Chairperson, just to close off on the issue of questions to the President, and I'm sorry, Chair, to do this to you. I'm worried, Chairperson, about the deadline not being finalized in this meeting. I'll tell you why, Chair. We have been given an extension up until the end of March. And end of March, Chair, means the submission of the report to the House. Doesn't mean that by the end of March we should still be hearing oral testimonies. Now, my main worry, Chair, if you're dealing with 122 questions, as we currently have, you would at least, Chair, to give the President a week at the minimum to respond to that. And Chair, those responses will fit into the report of the committee. So I'm worried, Chair, about the fact that we're merely saying, no, we're sitting this week. You know, people can look at the questions and without putting a deadline, Chair, because our view was that during the course of this week, those questions must be dispersed to the President. And then, of course, as we said, 122 questions, reasonably, you would at least, at the minimum, give the President a week. So our main worry, Chairperson, is that witnesses are being scheduled up until the 2nd of March. And we presume that the remainder of the 2 weeks will be about report writing, toing and froing, you know, members, panel beating this and that. And we're worried, Chair, we're concerned, Chair, that no deadline is being put. Chair, let me speak about the last correspondence. The last correspondence, Chair, you will recall that at our last committee hearings, when Mr. Paul O'Sullivan was appearing before the committee, that was on the 11th of February. There was a DSO dossier that was circulated by Honorable James. So Mr. Paul O'Sullivan has written to us saying that the name of the person who is mentioned there is someone who was persuaded by Mr. O'Sullivan to turn as a Section 204 witness. And Mr. O'Sullivan's apprehension or worry is that if that goes into the public domain, the person affected, the person, can even be at risk of being murdered and so on. He raised a number of things, Chairperson, but at the end, he makes a request. I'm assuming, Chair, that members went through this meeting. So at the end, Chair, he makes an urgent request. He says, as a result of all of the above, I humbly and urgently beseech you to have an off-the-record meeting with all members of the committee who may have been provided the document, Ms. James, unlawfully published. At such meeting, require all of them to destroy the unredacted version of the document, Ms. James, unlawfully published. Since I do not want to be accused of trying to cover up the document itself, the said members could be issued with the attached redacted version, because he sent us a redacted version, which will ensure the protection of the safety of the person that I turned into a valuable witness to help take down an international drug cartel. Finally, when transcribing the record of the meeting of the 11th February 2026, to have the said transcription redacted, to remove the name of the person mentioned by Ms. James and inadvertently, repeatedly mentioned by me, which is Mr. Paul O'Sullivan. Again, this is necessary to prevent a possible murder. So that's what Mr. O'Sullivan says, but it's just that my main worry, and personally, is that it seems as if that ship has already sailed, because I think the document is in the public domain already. But Chairperson, I leave it in your capable hands to deal with it. Thanks, Chairperson.
So, what is the recommendation you are putting before the committee?
Look, Chair, I've always, in fact, Chair, it's not a question of I've always. The terms of reference, Chairperson of the committee, paragraph 5.1, they say that the inquiry is an inquisitorial process informed by Parliament's constitutional oversight mandate. It is neither a judicial or quasi-judicial process, nor is it an adversarial process. So all that I want to say, Chairperson, is that my view is that, Chair, if we have information, Chair, on people who are going to appear before the committee, I think, Chairperson, fairness dictates that those people have sight of those documents in time, so that the proceedings themselves don't turn into accusatorial proceedings. But, Chair, as I've said at the end, my main worry now is that, and I said this when I was discussing this with Council, I said my main worry is that we seem to be giving a time to a document which had no airtime completely, because the copies which were distributed that day, yes, they have the name, but Chair, I don't remember seeing any of the reputable media houses reporting on it. But Chairperson, as to what the recommendation is, I think, Chair, my concern is that that horse is bolted already. And I think looking forward, for me, it's just a question of in future, perhaps we can handle matters like this in a sensitive manner. I don't know, Chair, if I'm making sense. Leave it there. Thanks.
Okay, let's hear the members, what the members are saying. The ANC. The MKP. The DA.
Yeah, I don't really have a view. I haven't had sufficient time to consider it. So I don't really have a view. I'll hear what the rest of the committee says.
The EFF.
Chair, I don't know what or what decision we need to come to now as a committee, but I do think going forward what we can agree on is that whatever additional information we might have, that we send it through the evidence leaders, etc., and that would be in the interest of fairness. But that's also with the understanding that sometimes during our sit-ins, or during our sit-ins rather, people send us information, and yeah, sometimes we press for time, or the moment is there. But I think just for us to be more disciplined, and perhaps we just process the matters with the evidence leaders, and maybe we could even take a 5 or 10 minute break when we do get that information and be able to deal with it. But regarding the actual matter that Paul O'Sullivan has raised, it's something that we also as the EFF would need to apply our minds. Thank you, Chair.
The Patriotic Alliance.
Chair, I don't think we need to have a sit down with Mr. Paul O'Sullivan and destroy the document in his presence. I think I disagree with that. But we focus on the reason for such a request is to protect a 402 witness. So maybe we should consider it from that angle. What protection is necessary? His request is destroy the document. So, and then if the document is published, so we destroy the version we have. But if the document is published, so he's not against the document being published, but if it is, it must be done in the format that was sent with the 402 witnesses information hidden, so that his name and that is scratched out. So I think it's just a matter of being clear that Honorable James was not wrong in producing the document, because it was part of the interrogation and necessary for him to respond to that. But in the concern of post the engagement, to protect the person mentioned in there as a 402, it should just be said that if it is published thereafter, I don't know if Honorable James published it, but if it is, then the version of the document published should be the one that has the 402 witness scratched out. So without having to sit with the whole committee, to sit with him and destroy in front of him, I think the protection of the 402 witness is the concern, and that approach, I think, should suffice, Chair. That's my submission. Thanks.
Honorable
Owen,
Vessels.
Owen, and we do take the advice from Mr. Dejana around when we have information that we run it by legal and so on. So that advice taken. Thank you, Chair.
Okay. Honorable Vessels.
Thank you, Chairperson. I think we should apply our minds further to this issue, but I don't see a problem with redacting the witness's name in any documents that we produce for the record. But I think let's apply our minds further. Thank you.
Okay. Honorable James.
Thank you, Chair. I think firstly, just to respond to Honorable Salts. No, I did not share that document anywhere on any public domain as in social media. But I did see that afternoon after we had circulated it to members, it was all over Twitter. So I'm not sure if some of the members actually leaked this to their colleagues or media contacts and how it found its way onto Twitter and Facebook and all of that. Nevertheless, the document relates to a matter, the document that was presented to the members that day relates to a matter that was widely publicized in all newspapers, in the news some time ago. I'm just going to have to get it again so that I can actually present it to this committee. So I'm not sure what he's saying that, it cannot be out there in the public domain, and the fact that we are sort of endangering lives and whatever. This, I just have to double check. The person that is mentioning has been mentioned in several other newspaper articles, if it is the same person. I just have to double check that and then get back to the committee. I also agree with what EFF said now. They actually covered me. At times, we literally get the information while that person is appearing before us. We'll get a WhatsApp, we'll get something, we'll get a document to say, ask him on this. But I think when it comes to, we should just have a general rule then, if we do get information beforehand, to then give it to the evidence leader so that the witness can also have it before them. It also saves time. But I think Mr. Paul O'Sullivan is taking a fat chance here, because everything that was in that document was out in the public domain. Thank you, Chair. I'll just confirm if it's the same name that is mentioning in here. Thank you.
Thank you so much, Honorable James. Honorable members, let's take
Chair, don't forget about me because of the network. Sorry.
Okay. Honorable Scosan.
Thank you, Chair. I'm sorry, Chair, I'm struggling here. But I just want to say as well that the issue, I agree as well with, you know, a lot of my honorable colleagues here. You know, Matthias has put it nicely, and Saul and Honorable James and Vessel, everyone here. But we cannot allow as well, you know, Paul also Sullivan to dictate terms like he is alleged that he was doing with the security cluster. You know, if there's anything which is wrong as well, because he's coming back, you know, we are going to ask him question. For him to say that he's in danger, he's been saying people want to murder him. You know, we can't be taken for a ride by Mr. Paul also Sullivan. He call us names. You know, anyway, I'll have my chance because the thing which he said on the media, you know, and he has to account for that. He is taking us for a ride in a very, very serious note. He thinks that we are a joke. You know, Chair, he cannot dictate to us, Mr. Paul O'Sullivan. He's equal to like any other witness who came before us. He wants the rules to favor him. He wants to dictate to us. No, we cannot allow that, Chair. Thank you.
Okay. So, honorable members, let's agree that is this hand that is up yours, Honorable Skosana?
Thank you.
Honorable Matthias, your hand is up.
Yes, Chair, it's not a legacy hand, and I'm so sorry to do this. But I just went through the letter in more detail. And that last paragraph from Paul is even threatening us again. And he's telling us that he's going to have the Mantla commission to investigate the ad hoc committee members. Like, what? Chair, no, he's just out of order. I don't even know why we're even entertaining his correspondence right now. I mean, if he had an issue to raise, he should have just raised it, not come and threaten us about going to the commission and have us investigated to be parts of drug cartels. And I think we must just notice that also in our minutes. I mean, his correspondence is just becoming a bit overly pedantic now. And we've got more important things to be worried about. Now we must be spending almost an hour discussing his letter. Thank you, Chair.
Okay. Can we agree that if we have any information that we may want to ask the witness on, we will run it by the legal team? Agreed? And then with regard to the matters that Mr. Paul O'Sullivan is raising, the general feeling that I hear from the meeting is that let's get more advices on it. And once we are sure that we have been properly advised, we can resolve on this matter. Agreed?
Agreed, Chair.
Thank you so much. Can I check if we still have a quorum in the meeting, because we must now go to the minutes? Who is present from the ANC? None. MKP?
Thank you, Chair. And I guess they've sum it up because we spent too much time on the Apollo Sullivan once again. From
Yes,
MKP.
yes. You are present. You are present. DA?
It's myself, Chair, Mr. Cameron and Mr. Klopper.
Okay, it's 3. And then EFF?
I'm here,
4.
Matthias and Honorable Malemba just had to step out.
Yes. So Honorable Souls, you are here is 5. Am I correct?
Yes, sir.
And then in the absence of Honorable Mngango, Honorable Vessel steps in. Am I correct?
I'm here. Yes, Chair.
Thank you. So it's 6 plus the chair. We have 7 members, so we can adopt the minutes. Pilot, honorable members, the minutes have been circulated with you for about 2 weeks. What I'm going to do, I'm just going to take them date by date. Pilot, can you flight the first set?
We've got the minutes of the 16th of October, Chair. They are flighted.
Oh, okay. I think what you should do, you just say I'm on page 1, page 2, page 3 until the last page, and then we move for adoption.
Chair, we've got page 1 on the screen. We are on page 2 and page 3.
Okay, can I check if there is any mover for adoption?
I move.
Honorable Breitenbach move. Any seconder?
I'll second, Chair.
Honorable Matthys. Honorable Matthys, your hand is up.
Yes, Chair, are you not asking us, are there any amendments per page? Or what we can do is that as the EFF, we've got some amendments that, or information that is not in the minutes that we think should be there. So I don't know if you want us to send you, because we have it in writing, or whether you want me to read them out here.
Yeah, you can read.
Okay, on the 15th of October, on the opening remarks, if we go to the opening remarks, it's not indicated that the members had directed that the meeting should be held with the chairperson of the Joint Standing Committee on Intelligence. And I think that was important that we have that noted, because it's still an ongoing issue. So that's not noted in the minutes there under the opening remarks. And then on paragraph 1.7, the list of witnesses who had not been consulted, there was some names that were omitted on the witness list who had not been consulted, and they should have been added on there. And that was some of the issues that came up during the deliberations. And then on paragraph 2.3, we can skip that one. And under the witnesses that were discussed, if we go further down, there's no movement here. That the names of Mkhwanazi was put already on the minutes of the 15th of October. Also, Paul O'Sullivan, Richard Mkhwanazi, and as well as Molefe were already put as the witnesses discussed, and it's not captured in the minutes, in those minutes. And that's our amendments. Thank you, Chair.
And then with those amendments, you move for adoption.
Yes, Chair, thank you.
And then are you still seconding Honorable? Who seconded? Honorable Breitenbach moved, and Honorable Matthys came with the amendments. Can I check who seconded the adoption with the amendments?
Chairperson, I did second, and so did Honorable Vessels.
Thank you so much. Can we then agree that the first set has been adopted? That is the 18th pilot, no?
Mm-hmm.
Pilot?
Yes, Chair. It's on the 16th.
The 16th of?
The 15th of October.
The 15th of October.
Yes.
Thank you. The minutes of the 15th of October are presented and adopted with amendments made. And then can you then read the second set?
We have got on the screen the minutes of 29th of October, Chair.
29 October, you can take them page by page.
Page 1 is there. Page 2. Page 3. Page 4. Page 5. And then page 6 is the last page.
Okay. Can I check if there are any corrections or proposed amendments? Any mover for adoption?
I'll move.
Honorable Breitenbach moves. Any seconder?
I'll second.
Who is seconding?
Sorry, it's Honorable Croker.
Okay. Honorable Topper seconds. Can we move to the third set?
We've got the minutes of 10 November, Chair. Page 1 is there.
Thank you. Let's proceed.
Page 2. Page 3. Page 4. Page 5 is the last page.
Okay. Honorable Vessels.
Thank you, Chairperson. I just see that my apology was not noted, and I did send an apology to Vahani for that meeting. Oh, sorry, I was present. I apologize. I apologize.
Okay. Honorable, is there any further correction or proposed amendment? Honorable Matthews.
Thank you, Chair. It's just a typo, really. Paragraph 2.3, but maybe not. You've got Honorable Makhlala, 2.3. So that needs to be fixed.
Okay, and with that correction, you move for adoption.
No, I do, Chair. Thank you.
Okay, any seconder?
I will second, Chairperson.
Thank you so much. The minutes of the 10th are adopted. The next set, Mr. Pallet.
We've got 17.
Mr. Pilot?
Yes, Chair, we have got 17 October, page 1, page 2, and page 3.
Okay, that is the last page.
Yes.
Any corrections or proposed amendments? Your hand is up, Honorable Matthews.
Legacy hand, Chair, sorry.
Okay, thank you so much. Any mover for adoption?
Chairperson, I will move. Diamond Club.
Okay. Any seconder?
Second, Chair.
Thank you so much, Honorable Skosana. Can we move to the next set?
Court Chairperson, we've got 21 October 2025. Page 1. Page 2. Page 3. And page 4. Page 3 is the last page, Chair.
Okay. Can I check if there is any correction or proposed amendment? Okay, any mover?
I'll move, Chair.
Thank you so much. Any seconder?
Chairperson, I'll second.
Thank you so much. The minutes of the 21st of October are adopted. Next set, palette.
October, Chair, page 1. Page 2. And page 3.
Okay. Any point of correction or proposed amendments? Any mover for adoption?
I'll move, Chair.
Thank you. Any seconder?
Chairperson, I'll second.
Thank you so much. The minutes are adopted. The next set palette.
November, Chair. Page 1.
24 November. Yes.
Page 3. Page 4.
Any correction or proposed amendment? Mover for adoption?
I'll move, Chair.
Thank you. Any seconder?
I'll second, Chair.
Thank you so much. Next set.
Chair.
Hello, Honorable Skwasana.
Chair, can I make a proposal, Chair?
Yeah.
Can we take a so-called tea break, Chair? Looks like there's, I don't know, yeah.
No, we're
The Chair
about
is
to.
laughing at me. But this is what I'm realizing, Chair, to say when you ask a mover a second, it takes time now. Thank you, Chair.
We're about to conclude the meeting. We're on the last item.
No problem, Chair. No problem, Chair. Thank you.
7 January, Chair. Page 1, 7 January.
Yes, page 1.
Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. And page 8. Thank you, Chair.
Any correction or proposed amendment? Any mover for adoption?
I'll move, Chair.
Any seconder?
I'll second,
I'll
Chair.
second, Chair.
Thank you so much. The minutes of January 7, 2026 are adopted. The next set palette.
Chair, is it only silent on my part or?
Yeah, we're still waiting for Mr. Kwebu to light the next set. Honorable Skosana, is your hand up? Mr. Kwebu.
We are loading, Chair. I'm getting assistance from my colleague. We are loading.
Okay.
Chair, are we still on? I can't hear anything.
Yes, we are still here. We were asking you if your hand is up.
Sorry, Chair.
We have got 19 January, Chair, on the screen. Page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. And page 8. Good, Chair.
Thank you. Can I check if there is any correction or proposed amendment? Any mover for adoption?
Okay.
Any seconder?
I'll second, Chair.
Thank you so much. The next set palette.
We got, Chair, 24 October. Page 1. Page 2. Page 3. Page 4. Thank you, Chair.
Any correction or proposed amendment? Any mover for adoption?
I'll move.
Any seconder?
I'll second, Chair. Doesn't look like there's anyone else left on this meeting.
Yeah, you must second if nobody seconds, because the meeting still has a quorum. Next set.
Second of February, Chair. We've got page 1 there on the screen.
Yeah.
Page 2. Page 3. Four. Page 5. Page 6.
Correction or proposed amendments? Any mover?
I move, Chair.
Any seconder?
I'll second.
Thank you so much. Palette, do we still have another set?
28 October, Chair. Page 1, page 2, page 3. Thank you, Chair.
Okay, any correction or amendment?
Chair,
Honorable Mathais.
thank you, Chair. The minutes that we have, the only minutes that were circulated to us prior to this meeting were the minutes of our ad hoc meetings, not the proceedings where we've actually had witnesses. So it's very difficult for us to go through these minutes so quickly and as they are moving, especially, well, particularly the ones that include the oral evidence by our witnesses. Were you aware that we didn't get these minutes
We
for the oral
circulated,
evidence, not the oral evidence?
we circulated seven sets of housekeeping meetings and 7 sets of proceedings.
Okay, Chair, I'll go through the WhatsApp group, but I don't remember seeing the oral. I just saw the ones of the meetings. Thank you.
Yeah, no, it's 7. What date is this one palette?
28 October, Chair.
And how many sets are left? I mean, the sets that you circulated, how many are left?
We should be left with about 4, Chair.
No, I mean, we circulated seven sets of minutes. I want to know how many sets have we done so far and how many is left?
We are left with 4, Chair. We've done 10.
Okay. So this is the 28, you say 28 October.
Yes, Chair.
Okay. Can I check if there is any correction or any amendment? Any mover? Seconder?
I'll second.
Thank you. Next set, palette.
24 November, Chair, page 1. Page 2. Page 3. Page 4. Thank you, Chair.
Okay. Any corrections or proposed amendments? Any mover?
Shall move.
Any seconder?
I'll second.
Thank you so much. Next set palette.
Chair, that was the last set we are done, Chairperson.
Okay. Thank you. Thank you so much. Honorable members, can I check because I think there is one item that Honorable Mr. Tejana spoke to. Do we want to put a deadline on the question to the president? Mr. Tejana, the consolidated questions have they been sent out to members?
Correct, Chairperson. That's my understanding, Chair.
Yeah, can we get that confirmation so that members, when they leave this meeting, we know when can they respond to the question to those questions?
Hi, Chairperson. Chairperson, in the group, Venetia confirmed that I think I'm not sure whether it's Pilate or Babalo circulated the questions, but they've been circulated. Already. That's the impression I get when I read the WhatsApps in the group.
Okay, members, can we agree that by close of business on Wednesday, we must have got the responses? In the event there are no responses, the questions will be forwarded. Honorable Matthews.
Chair, I'm here in the group. When was it put in the group?
Mr.
Can we
Tejan.
get an indication?
Okay, Honorable Matisse, I'm just trying to check my WhatsApps. I think, tell me, maybe we should ask this from Pilate. Sorry, Pilate, I'm not throwing you under the bus. Have the questions been dispatched to members? Because Venetia says questions have been sent to Pilate.
Chairperson, the questions will be posted in the group.
Yeah.
I was saying we are going to post them in the group.
Do you have the questions?
Yes, Chair.
Okay. Can we agree, honorable members, that we must check those questions and indicate if we are happy by Wednesday close of business, we must have got the responses of members. If we haven't got those responses, we are going to forward those questions to the office of the president. Number two, are we agreeing to start at 10 o'clock tomorrow?
Yes, Chair. Thank you.
Agreed. Thank you so much. And the last announcement that I want to make before I close the meeting, tomorrow will be my last day of attendance at the University of Johannesburg, so I'm going to miss tomorrow's meeting. The members would have to arrive a bit earlier to agree on who will chair tomorrow's proceedings. I will only join the meeting on Thursday and Friday.
Excellent.
Thank you. Honorable members.
If I may, Chair, if Honorable Mola is at the meeting, don't we have a standing arrangement that you will chair?
It was a standing arrangement for committee meetings. For the proceedings, it still has to be finalized. I mean, it still has to be formal. It has to be formal.
The correct procedure, Chair, sorry, is that we elect a chair.
That's exactly what I'm saying, that it must be formalized. Thank you so much, honorable members, for your inputs. It has been a very long meeting from 2 o'clock now. I mean, from 1 o'clock.
Yeah.
Yes. No. From 1 o'clock until now, I must thank you so much for your commitment. This meeting has unfortunately come to an end until we meet again in the next proceedings. Thank you so much.
Thank you, Chair. Thank you.
Thank you, Chair.